Okay, let's reconvene the oil and gas hearing for July 20th. We did have an executive session. I'll ask the Assistant Attorney General, Jake Matter, to review what was discussed.
Yes, during the break, we went into executive session pursuant to the Open Meetings Law, Section 4023A2, to discuss the items identified on the agenda concerning the establishment of default standard size drilling and spacing units and a quick status update on the Marilex versus COGC case number identified as 2014 CV 34759. No other topics were discussed and no decisions were made.
I'll entertain a motion then to come out of executive session and to reconvene in.
So moved. Second.
Moved and seconded to come out of executive session. All those in favor indicate by saying aye.
Aye.
Opposed, same sign. We are out and in a regular hearing. Now, I have no idea where we left off. I have a rough idea, but maybe we're at a rebuttal point, or?
Yeah. That is correct, Chairman.
Okay. I am really pleased to see they brought their best shooter. Mr. Nesley.
Yes. So I'm prepared to provide rebuttal on behalf of the industry parties. I don't know whether you'd like to hear that before Mr. Lepore reports on his proposed language. Whatever your preference is, Commissioners.
Ambivalent. Let me check with Mr. Lepore to see if he wants to take the first shot across the bow.
Mr. Lepore, do you want to present your revised language to the Commission before the industry offers its rebuttal, or would you like to go ahead?
My proposed language doesn't address all of the issues, so why don't you tackle the issues? You know what my proposed language does address. Can you dance around those?
Certainly.
I don't mind going next, but
If it's okay with you,
I'm happy to speak at this point, Commissioners. Dave Neslin again, Davis Graham & Stubbs, appearing on behalf of the American Petroleum Institute, doing business as the Colorado Petroleum Council. I'll be offering some short rebuttal on behalf of the industry parties who've testified here or spoken here this morning. I'm going to address what I think is the crux of the remaining issues, which is the standard of review. I'm going to make 3 points regarding the standard of review this afternoon, and I'm happy to answer any questions about this. The first point is there's a substantial difference between local land use enforcement proceedings and enforcement proceedings by this commission. By state law, by state statute, local land use penalties are set at $100 per day. That's state statute. This commission issues penalties of up to $15,000 per violation a day. So there's 2 orders of magnitude difference in the potential penalties you face in a local land use proceeding and a enforcement proceeding by this commission. That's a very important contextual difference, and it explains why looking at any local government's land use process is a poor guideline for this issue that we're talking about today. It bears directly on the importance of predictability and certainty in the process that we're trying to develop with this petition of review regulation. That's the first point. The second point is that the dictionary definition that Director Lepore read of clearly erroneous is a firm conviction that a mistake was made. I would suggest that anything less than a firm conviction that a mistake was made is a possibility or a speculation that should not form the basis for reversal of the director and his professional staff. You should not be reversing the director and the professional staff because of a possibility or a speculation or anything less than a firm conviction in your minds that a mistake was made, and therefore clearly erroneous is the appropriate standard. Third point is, speaking as a former director, some enforcement decisions involve both art and science, right? There's an element of both. And some deference is appropriate for two practical reasons. I don't want to burden you with any more legal discussion. You heard enough of that before lunch, but two practical reasons. First, it's practical to provide some deference to the director and his staff because they work at these issues full-time and they have extraordinary expertise. You have a staff, you'll be up to, I think, 111 professional staff in a variety of disciplines such as geology, hydrology, engineering, biology, environmental science. Most of the staff, many of them have not just undergraduate degrees, but graduate degrees. You've got PhDs on staff. At least when I was here, the average staff experience was 2 decades. So these are people with a lot of practical experience as well. And so it's entirely appropriate to rely upon the director and his staff. And the director has 3 or 4 compliance officers who do this on a full-time basis. He has recourse to multiple assistant attorney generals, such as Mr. Matter. As a practical matter, it's appropriate to defer to the director and the professional staff on these decisions. And it's also efficient, again, because the staff, the director and the staff have seen the witnesses. They've visited the site. They've examined any documentary or physical evidence. And so unless you want to convert these petitions for review into full-blown trials in which you're going to have all of the evidence presented to you in detail, which is going to be much more time-consuming and a much slower process than you contemplate, some deference is appropriate because the director and the staff are the ones who have reviewed all of that evidence in detail. So those are, if we enumerate them, 3 or 4 practical reasons why the standard recommended by the staff and supported by the industry is the appropriate standard here. And that's the clearly erroneous, clear error standard. I'll stop there. That's the only issue I intend to offer any rebuttal statements on. I'd be happy to answer any questions that you have regarding that or any other issues that you would like to hear from me or others on the industry about.
Any questions for Mr. Neslin? Thank you very much, sir.
Thank you, commissioners.
Okay, are there any rebuttals to be offered by any of the other parties? We had Weld County, we had Boulder County, we had Longmont.
Mr. Chairman, I did have a question for the industry parties, but are we going to have another opportunity to present those, or have we moved on to local governments?
No, I think we'll just, if it's okay, well, if you'll forgive us, we'll back up and direct the question to industry. You don't have to leave.
We're here.
Get close to a microphone when you respond.
Thank you.
Thank you, Mr. Chairman. Thank you, Ms. Jost. For whomever from industry wishes to respond, the local government officials from the parties, and I'm making a distinction because Weld County apparently also is of course also a party, but they didn't raise this issue. The notice pleading versus pleading with particularity. I guess I would appreciate it if somebody from industry, representing industry, could respond to the question or to the point made that it is it would be that a notice pleading is sufficient and that that it's overly burdensome to require the pleading with particularity. And I think it was Mr. Wanstallin who presented this piece, but no, it's an API. It's Mr. Neslin.
Yeah, again, I think the industry believes that a with particularity standard is appropriate for this purpose, given the magnitude of the potential penalties which are at issue, which run up to $15,000 a day, and the fact that almost by definition, when the issue is raised in a petition for review, it's a challenge to a decision that the staff has already made on these issues. So under these circumstances, to require the petitioner to identify with particularity what the issue is appropriate. These are not securities violations, which might involve particularly complex combinations of factor law. The issues we've been talking about here are somebody claiming that I assume their groundwater has been impacted or their air has been impacted in some way, or that
I'm sorry, excuse me.
or that they require some additional time. They've got an expert now who's become available. I think they can identify that with particularity.
We do see a lot of pro se parties here, however, and that point was raised before, and obviously it stuck with me a bit. I mean, if we got to even an on-the-record only review or an on-the-record review, I mean, the points would come out or wouldn't, would they not?
But of the 4 situations where a complainant has sought to avail themselves of bringing an enforcement issue to the commission, in the 3 of those that occurred within the last 4 years, they all involve situations where they were represented by counsel.
They were represented by counsel.
Yes, in each case.
Okay, thank you.
I'd like to add just one more thing. One of the things I want to just remind the commissioners of is at the time you hit the petition for review proceeding, the complainant will have already gone through the Form 18 process. So that's kind of your notice pleading piece at that point. A petition for review does have a matter of specificity that should go with it. And so I think that's where the with particularity comes with it, because you're already on decision, asking for a separate decision on decision number 2,
Right.
I should say.
Okay.
Thank you.
Thank you all. Appreciate it.
There you go, sir. Thank you.
Mr. Kramer, sorry to interrupt before. Thank you. Thank you, Mr. Chairman.
Please proceed without interruption.
Commissioners, Dan Kramer again for the city of Longmont. I was going to say I have no specific rebuttal, but I'm just up here to present myself for questioning in case there are questions that have cogitated over lunch break. But I will respond to one thing Mr. Neslin said. The amount of money in question should not be relevant to whether a petition needs to be pleaded with particularity in a court, since we do find it useful to compare to courts. The amount in question has nothing to do with the pleading requirements, even if it's millions of dollars or billions of dollars for that matter. It's notice pleading in almost all cases. So that said, I'm just here for your questions.
Any questions for Mr. Kramer? Hearing or seeing none, thank you very much.
Sorry. I did have one.
Wait a second, I'm sorry.
Weren't fast enough.
Sorry. Couldn't dodge the bullet there. There was a couple of places in here, and I have to go back and look, where the industry recommended a slight revision to say that this would only apply to, I think, Class 2 and Class 3. That was not addressed. Just wondered if that was something you might have an issue with or not.
I will tell you this, I do not know the difference between Class 1, Class 2, and Class 3. It's not something I've researched.
Okay.
But the reason why is because I believe those suggestions didn't come in until last Thursday evening or afternoon after the deadline, and that those requests were stricken from the record.
Okay.
Okay, other questions?
Going once.
Thank you, Mr. Kramer. Now, Mr. Lepore, would you care to rebut the rebuttals or?
Thank you, Mr. Chairman. So this was language that I have circulated to the parties, and I made like 10 copies, so they're available. I changed one word after I gave it around. I changed in the first sentence of blue, including any evidence. It said and information. I changed it to or. I know that industry still objects to the unless agreed to by the parties language. That's why I put that in red. Otherwise, I would offer this as the wordsmithing that was discussed to make it clearer that if there is that continuance and additional investigation, any evidence or information developed through that process is not new evidence. It is presumed, well, it will be given to the director, and the director can do what he or she will with that. And then when it comes to you for petition for review, that is part of the record. I guess that's the clearest way to say it. Whatever is developed during that continuance is part of the record, and there's no objection to that being presented to the commission on review. The last blue sentence, the commission retains discretion, was just, again, to clarify what in my view is the state of the law, the state of our rules. You could either sua sponte on your own motion without any request from any party, or in response to a request from a party, say, I don't think this is ready to be heard because I think there's additional investigation that needs to happen here. And you could send the parties or the staff off to do that investigation. And again, whatever was developed through that process would be part of the record. I don't think, obviously you want to hear from everybody, as do I, but I don't think there's really any disagreement. I think there's general agreement about all of the language except what is in red. No? Okay, so I guess I'm not overly surprised, but they can have their turn.
Okay.
Correct, Commissioner.
Any questions for the director? Yet, if in fact there is not agreement, perhaps we could hear as to where the disagreement lies.
Absolutely. Thank you. I will start off with the agreement. The first blue sentence, industry is okay with that language. As Director Lepore said, we do not believe the unless agreed to by the parties needs to be in there. It seems superfluous and excessive in this rule. If the parties absolutely choose to make that determination, they can do so at a pre-hearing conference. We do not think it's necessary in the rule. The last line is good until you hit the or the parties to conduct additional investigation. It's always been our understanding that if there is additional investigation to occur, that is limited to the staff as directed by you, the commissioners. The parties should not have the ability to basically go back and re-allege their new complaint or their original complaint. I think opening it up to or the parties may end up in that result.
So I just like to read this the way I read it. No party may present evidence that was not previously presented means we have a nice clean appellate procedure unless the parties agree to convert it to a quasi-evidentiary proceeding, which brings it back into unlawful territory because you have parties presenting evidence to the commission in the context of its enforcement capacity. And the last sentence, as you remember the bullets, you can delegate your inspection and monitoring function, but not your investigative function in the context of an enforcement proceeding. This says you may authorize the parties to conduct additional investigation. What the staff has in mind there, I don't know if they believe that encompasses discovery, but the investigative function belongs to your staff and not to the parties. So those are still problematic.
Yes, sir.
You may.
Director, please.
So we talked during the main part of the hearing about our missing in action expert who was in Jamaica. And that expert comes back and the proponent says, at long last, I can interview my expert. That's the parties. That's not me. I'm not going to go interview the expert. I'm not getting an expert report. That's the parties. Likewise, if a proponent says, But I know for a fact X, Y, and Z happened. I've been told. But I need discovery. I need to do some additional investigation to get that information. I'm not doing that. I'm giving a continuance of the investigation process to allow that to happen. So, but in response to Mr. Wanstolen can't imagine what we're talking about, that's what we're talking
No,
about.
that's just, the part, look, the complainant can always say, I'm going to go on my own, talk to my Jamaican expert. But if they want that come before the commission, they got to bring it to you first. And it's got to be put in the record. This says the commission can direct the parties to conduct investigation. It means someone's come in front of this group and said, there's evidence that you don't know about. And even though that first sentence says the hearing will be limited to evidence and information entered into the record, I'm going to tell you about other evidence that's not in the record. And I'm going to ask you to direct me to go do an investigation. You have to read this carefully.
So again, prior part of this rule says that in the first instance, the hearing staff will decide whether compelling evidence has been presented to warrant additional investigation. If I say no, if the staff says no, we don't think that's the case, that proponent should have the right to come to you and say, as a preliminary matter, just as the industry did today on their preliminary motion, say, you know what, we think the director was wrong. We think we have presented compelling evidence. And therefore, we'd like to ask you to direct that a continuance be entered so that this additional investigation can occur. That's all I'm trying to accomplish.
And if that occurs, it seems to me that we'll be directing you and your staff to at least oversee that additional investigation. Excuse me. So it's not like we're turning, so to speak, the parties loose to just go out and do whatever it is they think needs to be done. It's still under your and the staff's direction.
Yes, sir, I think that's accurate. And yeah, nothing here in my mind suggests even vaguely that you're deputizing the citizenry.
Commissioner King.
And it's becoming painfully obvious why Shakespeare wanted to kill all the lawyers. The key is that what does, if anything, come back in front of this body will be filtered through the presentation of whatever information, evidence comes forward through this extension through the director of the OGCC. This is not, we will not hear from the guy from Jamaica, or we won't hear from any of these other pieces of information that come up during the process. That's what all of us agree to. And that, you know, if it's the language that investigation is problematic, we can get around that. No one intends for any of this additional information to come to this commission unfiltered without going through the director and receiving his analysis, and we would get the recommendation from the director considering that new analysis.
I think I may have a proposal for, basically a resolution for this. If you strike the language "or the parties" and you refer back to COGA's proposed rule in 522B 5A through D that sets forth this procedure, you deal with these issues on that procedure set forth in Part C, Romanettes 1, 2, and 3, that outlines the actual procedures for determining when a continuance with an additional investigation is necessary. So I think it might be a matter of semantics at this point in time, but from the language as crafted right there, or the parties, does continue to have the problem, as Mr. Wanstolen said. But I think the procedure itself as proposed by COGA can get where the staff wants to be for purposes of what is represented to the commission.
You're referring to 522B5A?
Let me get there. Do you have
handout.
COGA's proposed language?
Yeah, page
Okay.
18 of your slide
Yes,
deck.
B5A and C. the request for continuance, because in that request for continuance, under portions 1, 2, it's Romanet 1, 2, and 3, it actually determines what should occur on that additional investigation. Right, which includes the right to come to you to ask for the opportunity to present that information,
Say it again, please.
which includes the right for that, I should say, complainant who filed the petition for review to come to you and ask for that additional investigation to occur. But there's not, let's just say, an implied delegation of the investigatory functions to that party. It still goes through the staff.
How about if we just get rid of the investigation entirely and say, review to direct staff to receive and consider additional information.
But how does that play into the parties?
The parties come out. Parties come out.
Yeah.
If you take the parties out the parties out and say to conduct, or I'm sorry, to allow the staff to consider additional information, that would likely be acceptable.
To direct staff. And so, yeah, it would.
Yeah, and take or the parties out.
Except then if we take or the parties out, then we lose what Director Lepore said.
No,
Yeah, because then it's,
I don't think you do. I think the commission can say, here is, it's the testimony from this guy from Jamaica, or it's a piece of information that wasn't available. Director Lepore, you are hereby ordered to consider that additional information and then provide a new report to us based on that, from whatever source it comes from.
so then he could go back to the parties and go get more information.
Right.
All right.
If I could, this is Dave Nelson on behalf of API. It doesn't limit or define where the information comes from. What it does is it specifies that you're continuing it to allow the staff to consider additional information from some source. I think there's agreement by all parties that would be appropriate.
Is it necessary to not call it an investigation if the staff are conducting it?
If the staff are conducting it, that's the COGA proposal. When you say direct the parties to conduct additional investigation, I read that as possibly encompassing discovery.
So it's just, there'd been some tossing around of just changing it to information. But if it's the staff, they can conduct additional investigations.
Direct staff to investigate, receive, and consider additional information. Did you live with that?
can you say it again, Director?
The commission retains discretion to continue a petition for review hearing, to direct staff to conduct investigation, receive and consider conceive and consider additional information.
I think that's, yeah, comment and consider or receive additional information. Say, consider additional information. Okay, I think that's fair. Thank you.
Smolder, Longmont?
Yeah.
Can you read it one more time?
Want me to try?
Here, I think I can edit the slide, can't I?
Oh, sorry, Director. Escape this screen. Can you edit this?
Direct staff, there you go.
Additional. That additional information would be brought up by the staff.
Is that what you wanted?
I can just go on the record.
Put comment, get rid of and.
And I guess I'd put into the basis and purpose, if we could, if we can live with that, that it is the intent, and maybe it's elsewhere in the rule, that there needs to be some showing that this information wasn't available during the original discussions with the complainant, rather than just, oh, we didn't think about it.
I would agree with that. You need
I almost wonder if you
sidebars.
haven't addressed that already where it says was not previously presented to the director.
Presented or available, I guess is what I'm saying. It's just the fact that you didn't present it.
Or you can say that presented or available to the director unless agreed to.
I don't like that change in that
Yeah.
place.
I think that is actually in the COGA rule proposal. We anticipated that as one of the criteria was that information, that the complainant did not fail to provide that information to the director.
Yeah, it's sort of implied within that wording already. I think the or available part's already in there.
Yeah, I think and I agree that COGA did have similar language to that in their proposal. And to me, that's embedded in the compelling evidence requirement. That's that would be a minimum threshold to show why you need more evidence. If it's like, yeah, I didn't think about it or I forgot or.
No, I think it's already in there.
Okay, oh, look at here.
Members of the commission, Dan Kramer, we're just having a little conversation over there about ands and ors. And I think that the language is probably clear enough. We just would like to clarify on the record that that or there doesn't make it an either or. In other words, the commission could direct staff to conduct additional investigation and to receive and consider additional information. I don't think it requires a wording change, but just wanted that to be clear.
Rules of drafting and interpretation in Colorado, that or is not exclusive.
I agree, and that should take care of it.
So that leaves the red language to go.
Are there other parties that have a comment relative to this language change? Okay, I believe we're through hearing testimony and rebuttal and proposal and reproposal. So
Thank
we're
you.
pretty close to closing the record and deliberating. Unless I hear an objection to that, that's what we're going to do.
Thank you, Mr. Chairman.
Okay, commissioners.
Mr. Chairman, is there some way we could get these, are there 2 or 3 issues framed so we're not taking this as a whole, but can deliberate on the sections that have been raised as areas of concern?
There's the standard of review. Excuse me, standard of review.
Okay.
There's unless agreed to by the parties.
Filing in reasonable detail or
Particularity versus
30.
reasonable detail. COGA still apparently wants a 17-part procedure for the hearings that have to happen when somebody files a petition for review with the commission staff.
And how erroneous you have to be.
That's the standard of review.
That's, well, yeah.
That was with particular. There was also, I thought, one about the type of violation, only for class 1 and 2 or something, or 2 and 3. Sorry, only class 2 and 3.
That was offered. I could make an editorial comment, but I won't. Remember that we're talking about things that complainants complain about and file and pursue and then disagree with. And that doesn't happen on class 1 violations very often.
That didn't matter. Okay.
Those are paperwork violations that's not really what complainants are complaining about.
They're going to complain about the 2 and 3s anyway. Okay.
Okay, which issue is first?
Why don't we tackle the clearly erroneous issue?
Very well. What's our sense on erroneous versus clearly erroneous?
Got a question. So are you comfortable with the changes that you just made?
The ones that, I'm comfortable with the ones that were on the screen.
So you're comfortable with everything that staff has recommended?
Short answer is yes, Mr. Holton.
I'd be in favor of just.
Subject to the change that was on the slide.
Yeah, subject to that.
if the commission wants to do it all at once, that's fine. But I think we've heard we maybe want to look at it at least briefly, with these various issues, beginning with clearly erroneous versus erroneous.
I'll just, if we're going to open that up. There was also a suggestion that was made about using the term arbitrary and capricious, which to me is very different from be it erroneous or clearly erroneous. And that last discussion that we had, that clearly erroneous is defined as a firm conviction a mistake was made. I am very happy to stick with clearly erroneous.
Well, and I agree with Commissioner Craig on that, I was concerned at first that was going to establish some kind of pretty high bar. But I feel like that it just means that we all agree that there was an error made.
Yeah.
And the complainant is held to that standard, which I think is an important part of the consideration. Any other comments? Clearly erroneous seems to be acceptable. Hearing no objection, then the next issue. Help me out. What's another issue?
With particularity.
Particularity.
Should,
Go ahead.
well, I guess the issue is since it's an appeal or review, and it's not going to be reviewing necessarily the facts of the case, it's more a review of the decision that the director made. Particularity might be the right way to look at this, that they have to be, pretty specific on what is it that they don't like about the decision, as opposed to we just think this was wrong and it was wrong because they should have found them in violation. And so, I mean, I'm struggling a little bit with that, and I think it is more of a legal term, and maybe we want to hear more from our attorneys on some of that.
Commissioner King.
I'm wearing out my welcome here today, but we've talked so much about terms of art, and pleading with particularity clearly is a term of art. I do think that as a practical matter, what we're trying to get at is you can't just come in and say, I don't like the decision, or I really don't like oil and gas activity in this location. Pleading with particularity requires the complainant to say something more about the specific act. That's what I think we intended. We used a term of art. I can't imagine this commission taking a hardline, rigid interpretation of pleading with particularity and saying, we're going to dismiss this because we're short of the legal standard of pleading with particularity. I could see us kicking it back and saying, look, you're not specific enough. We're going to, we're going to give you another 2 weeks to bring it back with more clarity and specificity. So I'm comfortable with the language requiring the pleading and the particulars, but I don't think we would ever, as a body, my guess is we would never apply that strict, rigid standard and kick something out because especially a lay person didn't meet whatever a court had determined to be appropriate. And I think we'd be more than justified in doing that.
Now, is it possible that a third party is going to come back and say, well, you did not follow that standard that you established?
Mr. Chairman, I think even if you were to apply a strict standard, I don't think a court would be required to dismiss with prejudice. I think a court would always be able to say, you can bring this back when and if you give us more specific details of your alleged transgressions.
Which I think that does present some difficulty, but I guess what and maybe perhaps our assistant AG can help me out here a bit with this, because it says what you have to do is it's the who, what, when, where, and why. But to what level of detail? I mean, that's not all that difficult to sort of answer those 5 items. Just, who did it, what happened, when did it happen, where did it happen, and why did it happen? I would think I would think there'd be some range of where a layperson could put that together without a whole lot of difficulty. But I'm looking for some guidance for you on that.
Well,
right now it says reasonable detail. So debating about reasonable detail versus particularity, and particularity is a term of art. And if you are an aggrieved person, the rationale is that you will know the details of any injury you have suffered, whether you think it's the fine is too low, an additional violation should have been issued, and so on.
So I guess I get back to
I
where.
think it's a matter of interpretation,
Yeah.
which I think is what Director King.
Yeah, so then I think I'm fine with that.
Commissioner Hallward.
I'm troubled of using the term with particularity if we're not going to use that standard. If, as Commissioner King said, we wouldn't kick something out, well, then why have that standard if we're not actually going to adhere to it? Why don't we go with the reasonable detail in which, to get the particularity of the who, what, where, how, and all that, we're asking them to do an investigation. And I thought we just agreed we're not having the parties do investigations. But if they have to come up with all that detail, that sounds an awful lot like an investigation to me, and that we've deputized them to do that.
Other comments? Okay,
Well, where are we
let's
going?
try to reach
So
some
reasonable
consensus
detail,
with
yeah.
respect to reasonable detail versus particularity.
The risk of being flippant, I would defer to staff and go with reasonable detail.
Is there some objection to that?
I have to agree with Commissioner Allward. If we're starting to get into terms of art, that always makes me very, very nervous for those of us who aren't familiar with the terms of art in the legal profession.
So reasonable detail, it implies it's more than just, I don't like it.
That's
It's-
right.
It's enough detail.
That the common
All
man
right.
can understand it, as
Right.
opposed to being a lawyer.
Okay, unless I hear objection, I'm going to say that's what we'll consider reasonable detail. Next item.
Matt.
So we've got the unless agreed to by the parties. And my guess, based on absolutely no evidence, is that even if that language isn't there, if it's agreed to by the parties, it can be brought in. So why not just strike the language? And my take would be that if it's agreed to by the parties, there's probably going to be a continuance and investigation and all that. So nothing's gained and nothing's lost.
Okay.
Yeah, I don't have
suggested that
any
we
problem
limit-
with that either. I think unless, I don't think that that's going to add a lot of clarity to when you're going to have the continuance then.
So we're in, I'm assuming, agreement that we can delete unless agreed to by the parties. And not hearing any objection.
Mr. Chairman, I'm not objecting. Is it out of order to put that slide back on the page, back on the screen?
No, I can do that just real quickly. Just watch.
Now I'm under pressure. Oh, I can't find it. Maybe it's that one. Oh, that's actually not it. You're gonna have to get it off the, maybe down here?
Yeah, maybe not quickly, but
But he can do it. Nice work, Mr. Chairman.
Oh, good.
Very impressive.
Okay, there it is.
Oh, good. So you're contemplating striking that language?
That's what we intend to do unless we hear some objection here pretty quickly. Okay. Struck through.
With prejudice.
Next item.
Emphatically.
Is there another item? Now, we had
COGCC procedures.
under procedures, we had some discussion. And as I recall, originally you had a timeline of something like 35 days. The next hearing.
Yeah, what I think COGCC is advocating for is, I don't know, Jamie, tell us, 522B, B5, A through D, which is that the staff has to hold a hearing upon filing a petition for review. There's a hearing within a specified time, an order within a specified time, et cetera, et cetera.
Which I think more or less they're already in there.
So is that, it's just moving the items that were item E, F, and G up into under item A? Is that,
No, that's not correct.
that's not me, I'm looking at the wrong.
No, it changes, that whole section gets changed around and relettered. Because they have A is worded, right now A, it says petition for review will set forth in reasonable detail the legal arguments. They have just filing and response requirements, and then that gets pushed down into B, and so then it all gets renumbered.
It's Exhibit 2. It's basically specifies almost a briefing schedule and a procedural mechanism.
Although when I looked at this on the COGCC proposal, slide 18, page 18, we have the 7 days under 522B5C, and then we have the 21 days under D, which are the two things that are there. And then somewhere in there, it also had the 2 hard copies, electronic copies. So to me, more or less, what's in the staff's proposed rules, unless I'm wrong, is also sits in this proposed rule by COGCC.
I think it just kind of put in a different location is my interpretation on it, but it's not changed from.
Director, would you care to comment?
COGCC's Part C has a number of procedural steps that are not included in staff's proposal.
Why do we need all those steps?
The original 2 hard copies, electronic?
No.
Oh, you're talking about 522B Part C.
Right.
That's under the request for continuance.
I think that's right.
Okay, that's different. I'm sorry. So it sets forth a timeline. That's on page 20 of their slide presentation.
Correct, it's page 20. 522B5C, page 20. Petition for review. I think that language in C is all pretty much there in our rule. It's the 1, 2, 3 after that that we, well, I don't want to make argument. We've made argument, but that's not in staff's proposal. That is in COGCC's proposal.
Okay, folks, what do you think? Off the top of my head, I'm saying to myself, do we really need to have
That's my
the
question.
process so rigorously defined? or can we allow staff to do that in a timely fashion in their, seems like I recall was a 35-day
35 total.
timetable.
I prefer the flexibility with the staff 35-day. I just think there, some things may be shorter, some may be longer, but if it's all fitting in the 35 days, it ought to work.
I'm going to argue that direction if I have to, but I'll leave it up to you all. So unless I hear objection, then we'll go with the staff's general proposal for a 35-day timetable for responding to a petition for review. Okay, no objection. Next item. That concludes all the,
I believe the last one was the CPA handout refers to class 2 or class 3 violations.
I had overheard the director saying that class 1 violations are rarely, if ever, a complaint and concern.
I think that was raised, but as I think you said that was not a significant topic of discussion. So I think it's the wording as it is today should just stand the way it is.
Okay, so we're going to basically accept staff's recommendation there and not exclude
Class 1.
class 1 felonies. No, that's not right. Class 1 infractions. So without objection, that's the direction we will go. Mr. Matter, have we overlooked anything?
I think that's it.
Commissioner Hallward, have we overlooked anything?
I don't know, I think the record's closed. I don't know if.
No, we have not closed the record.
I thought
we
we were
did.
Yeah, we,
I didn't hear it.
We actually did.
Okay.
What I was going to suggest that with our discussion, and I don't recall if this was addressed in the statement of basis and purpose, so I don't see a reason to change the rule of the 522B1D where it starts the local government with jurisdiction over the lands, someone who can make a complaint, that in the statement of basis and purpose, it could be stated that that includes if the impacts, are, that if the impacts are in that jurisdiction, then it's the same as it happening in that jurisdiction. If there's some way in our discussion, it came out quite clearly, not the garbled mess that's coming out of me right now. I think that would help with the clarity of somebody who's trying to work out whether they can complain or not.
I see.
If other commissioners feel that's
As I recall, we did
appropriate.
have a general agreement that, in fact, if the impact was felt in a neighboring jurisdiction,
Some sorts of impacts.
they would have a reason to become a complainant.
So I don't know
Unless
if
I
that's-
misinterpreted that.
I don't know how to do that. And so if somebody's got an idea.
And you're suggesting that be discussed in the statement of basis and purpose.
Yeah, I think it was presented very clearly that the rule as stated includes that. But whether, so that if the spill flowed downstream into another jurisdiction, that jurisdiction could initiate a complaint. If I'm misunderstanding that completely, then that's a different problem.
Well, that's what I heard in the discussion during the testimony and when the record was open. I just don't see it anywhere in our rule. And is just having it in the record or sufficient?
So right now, there's a very brief discussion. The statement of basis and purpose has a very brief one-paragraph discussion of Rule 503, which largely discusses the differentiation between an application and a petition for review. So right now, I think the statement of basis and purpose is really silent on that issue. And I know that Director Lepore discussed intervention, and I'm not sure there's a very specific change to the current practice intended by virtue of this rulemaking.
And current practice is to consider an adjacent jurisdiction if it's impacted. Is that true or false? Director, may I ask you that question?
Current practice is that anybody who is adversely affected or aggrieved may be a complainant. I mean, we have a list of people who can be a complainant. And if a local jurisdiction adjacent to where the facility was contended that it was being adversely affected or aggrieved, they can bring a complaint.
Okay, so that, and our intent is to continue current practice, so we may not need to change anything in this rule or the statement of basis and purpose. Okay?
Okay.
Any disagreement? All right. Then, Director?
So there's one change that we have agreed with. I think this was an industry proposal, and it simply relates to the order of presentation during a hearing, and it's under Rule 528C, so that the operator's response follows an intervener's response. That is the order that is in the rebuttals and in the presentations. So it's a change so that the response is consistent with the order of presentation throughout. Don't think there's any controversy. Just want you to know that compared to what you saw from us on July 10th, we would switch 13 and 14 in 528C. We'd switch them around.
Okay, well, I think we're close to someone making a motion to adopt.
Mr. Chair, you may be missing an issue that's already been raised. I don't want to reopen things, but COGCC and the industry were able to explain the issue that has already been raised and going forward. I want to draw your attention to city's summary number 2. The recommendation involved in clarifying in the statement of basis and purpose that the standing changes are not meant to preclude standing based on health, safety, and environmental impacts. Wanted to make sure you didn't lose that one.
I'm going to object to this because that was new evidence that's been presented. I'm trying to bring off the record that that can't.
Okay, I heard both of you.
Mr. Chairman, I think what Longmont's raising is it was a question that they raised that they wanted to have addressed. And it's not a new argument. It was on our to-do list that we didn't to do. So
I agree. Counselor, you had something?
Director King said it well.
Okay, does the commission want to address that, changing the language to be more specific?
I find that agreeable because it was actually a stumbling block for me when reading that statement in the rule about entitled to protection under the act. Just what did that mean? And it helped to read the statements from the various parties, understand that that was basically if it's within the jurisdiction of the commission, which would thus include health, safety, welfare, related to oil and gas operations. So I think that does help a party and a complainant to understand what their rights are.
So a simple statement that says with areas that are within the jurisdiction of the commission would be adequate? Or do we even need that?
Does it go into the statement of basis and purpose?
Yeah, I think that from my perspective, the chairman's question is right. Attorney General matter. Do we need this?
No, I think you could put that 1,000 different places in your rule book or in the statement of basis and purpose.
Or nowhere it
every
has
pa-
the same
right,
effect.
Every power you ever exercise is limited by your jurisdiction.
I guess then I would request that we consider putting it in the statement of basis and purpose so that at least it's there somewhere, even though we all know that that's part of our duty.
The argument is that, that's the rule by which we are governed. That's how
Yeah.
we always do business.
Do we need to have that in
So do
there?
we need to have it even in there?
I'd like to have it in there.
This is coming out of the blue. Besides your jurisdiction, you have standing issues of injury in fact, and the injury complained of is within the zone of interest protected by the act. You haven't had any discussion. I'm prepared to have that discussion if you want to. But if you're going to move down this road, we're going to do it another time.
That's not true. It was in our pre-hearing statements and I testified about it earlier.
It is true that it was brought up earlier. We did not have a lengthy discussion about it, but it was brought up.
There's a discussion of the Wimberley standard of injury in fact and zone of interest. You haven't had any discussion. You read it 6 weeks.
Okay, with that in mind, if we leave it the way it is, we don't mess with it, it's still understood that
Absolutely.
that's part of our charge. Okay. All right. Motion to adopt or not adopt, or
I got one more.
we could have a continuance or,
I got one more. 522B E. When we were talking about whether the infraction happened in Boulder County and it came into Weld County, or if it happened out in the county and came into my city, do we need to change any person to any party so that it would include municipalities?
I have to ask council.
So Mr. Wanstall earlier referred to and meaning or and vice versa. As a matter of statutory construction, person is the broadest thing you could consider.
Just want to make sure.
Okay.
One more. I'm going to float this one more time.
I'll move that we accept the rules as understood.
And we adopt the rules as amended in our discussion and deliberation.
Second.
I'm just asking, is that,
Is that what you meant? Okay.
Yeah.
And that's what he meant. That's what I seconded.
so we have a motion and a second to adopt the rules as amended in our discussion. Any further discussion? Hearing none. All those in favor indicate by saying aye.
Aye.
Opposed, same sign. The complainant procedure rules are adopted.
Oh, 2 hours late.
All right, Ms. Murphy.
Chairman, we're a teeny bit behind schedule. I'm hoping maybe at this point, we have a brief presentation from Director Lepore about docket numbers 1503-00186 and 1504-00265. And I would turn it over to him.
Okay, Mr. Lepore.
Because I was reading a bunch of stuff. So I'm glad we did, because that was, we're having all this discussion in the record. Glad we did. Somewhere I have a piece of paper with all this information.
That looked like a DHE mission.
All right.
Do we have a pause here?
Pause.
Is there an opportunity, or what's going on? I have a question for the commission.
We're giving Director Lepore just a little time to put together a few thoughts.
May I share one with my colleagues and our staff?
Please.
As we, I found that last exchange a little bit unsettling. And thank you, Mayor. As we head down the road towards subsequent rulemakings, perhaps council and hearing manager could share with all the parties at the outset the scope of our deliberations. In my mind, we don't need parties' approval to deliberate matters that we've had as in pleadings and of record for 6 days, 6 minutes, or 6 weeks. And I would hope that that's correct as a matter of law and that we have an equal understanding with our important stakeholders as to how we're going to comport our business in upcoming rulemakings.
Thank you very much, and I will convey that to the chairman so that maybe he'll have a little more control.
No, Mr. Chairman, it wasn't a matter of the chair's control. It's a question of making sure that all involved in this important business are on as close to the same page as possible. Thank you, sir.
Thank you. Okay, Mr. Lepore.
Thank you, Mr. Chairman. Thank you for allowing me to dig up the piece of paper that I wanted to read from. This is just to give you a quick update on the docket matters that hearing manager Murphy referenced, more commonly known as the Encana KPK spacing competing applications. After the last hearing here in front of the commission, I asked the principals to meet with me to encourage them to work through this on their own and find a solution rather than ask the commission to solve it for them. That meeting happened in May. Asked them to get back to me on July 6th with sort of a status report, a progress report. They have gotten back to me to tell me that they now have a letter agreement between them with at least a conceptual solution. They have asked for until September 4th to finalize the terms of that agreement. And we have acceded to that request, and in doing so, granted a continuance at their request until the October hearing on this particular matter. So hopefully they have found a way to get this off of your docket and find a business solution. If they haven't, in fact, done that, they will let us know by September 4th, at which time the staff will make recommendations as we see fit. So that's it. Just wanted you to know where that is.
Okay. Any questions? Thank you, Director. Docket 1507-00376. It's my understanding that there's no objection to this. In fact, it could have been on the consent agenda had we had enough advance time. So it's for information for the commissioners.
Actually, we chose to put this before you because unitizations are somewhat unusual. And so I believe Chelsea Russell and maybe Joe Pershala and their client are prepared to briefly give you an overview of what they're requesting. Staff supports their request and there's an agreed upon order, but unitizations are unusual, so we wanted you to have the benefit of their expertise.
Okay. All right. Thank you very much.
You up for it?
We are up for it. You give us your short version. We appreciate it.
We will.
We have a mouse.
If we see your heads bob, I'll talk faster. So thank you for having us here today. Staff asked us to present. My name is Chelsea Russell, and this is Joe Pershala, and we're with the Wellborn Sullivan Mekintuli firm here on behalf of Foundation Energy Management. And our expert geologist and engineer flew in from Oklahoma today in case you had any questions. And we also have our landman here as well to go over this presentation. See if I can find it. So Foundation filed an application in 1507-00376 to establish a unit for the Greasewood North Water Flood Unit. This will be a brief presentation just going over the basics and hopefully keeping you entertained. We're going to go over where the unit is, why we chose this well as the injection well, a quick discussion of the water that will be used for injection, a review of the economics, the tract allocation factors, and then a summary of the decline curves if you would like to see them. So the water flood unit is approximately 440 acres located in Weld County in sections 14 and 23. We've broken it down to 4 different tracts, and you'll see that the proposed injection well is in tract 1. In this unit, there are 7 wells that were drilled around 2001, 2004, and now there's currently 3 producing wells in the unit. For unitization, working interest is important. Foundation is actually the manager of several different entities, and between those entities, they own 100% of the working interest. Foundation is proposing to unitize the D-sand formation, and in this area, it's about 20 feet in maximum thickness and 6,700 feet deep. Get to my notes here. So we're looking to use the bad well to inject 500 to 1,000 barrels of water per day into the D-sand formation. And at this point in time, before secondary recovery, Foundation estimates that there's only 21% of the oil in place has been recovered today. So one of the questions that staff brought up was, why did we choose this well? It's not the most down dip well in the formation. However, because it's a marginal producer, it made the most sense to convert to an injection well. It was spud in 2004, and it was producing out of the D-sand formation. And the other 2 producing wells in the unit are definitely better producers. So this well seemed to make sense as far as location. And then also, as you see the graphs of the formation that we're injecting water into, the way the barriers work out, this well makes the most sense to contain the fluid. So this, another question that came up from staff was, where is the water coming from and where will it go? At this point, Foundation plans to use water from wells that they currently operate, produced water, and rather than trucking it to disposal locations, they'll be trucking it to this injection well location to use as injection fluid. And if they need more fluid, they'll go in and rework some of the abandoned wells that are in their area, this area. One of the questions that is definitely a hot topic in Colorado is, how will we limit the migration of the fluid? And in the D-sand formation, it's sandwiched between I'm not a geologist, so if I pronounce these wrong, I apologize, the Graneros formation and the Huntsman formation. And both of those formations, my understanding is, act as sealing formations. So any migration of the injection water will basically be captured between those 2 formations and stay within the D-sand formation. So the Huntsman and the Graneros formation limit the migration up and down. And this map shows how we perceive any migration going outside of the unit or not going outside of the unit. There is no permeability data in this area, so Foundation determined that there was a positive correlation between the porosity and the permeability in this area. And about an 8% porosity cutoff is what was used in this map. So the outer layer is, there's 0 feet with 8% or greater porosity, and we believe that the water will not migrate outside of that unit area. If it were to migrate outside of that unit area because of the Graneros and Huntsman formations, we believe it would stay within the D-sand formation, but we believe that's highly unlikely. So this is getting way out of my area of expertise. But the determination for the original oil in place as to why Foundation felt like this was a good area to unitize is based on their calculations, they determined there's about 1.2 million barrels of oil in this particular reservoir that falls within this unit. And that number was used in all of the economic calculations for our unitization agreement. This graph shows a comparison of other water flood wells that Foundation operates in the area. Let's see here. The black line, the lower line, is the Sooner water flood unit, and that is in Adams County, and then the Nile is in Weld County. And the table to the right shows a ratio of the secondary reserves over the primary reserves. And it shows them in each unit and then the predicted ratio for the Greasewood North unit, which is 0.16. So using that number and the estimated ultimate recovery, we are estimating that there's about 51,000 barrels of oil to be recovered in this unit. The development plan for the unit, and this is where most of the economic calculations come from. Foundation anticipates investing initial investment of about $200,000 into this water flood unit. And based on their calculations, they believe that there's about 21% is the current recovery factor. And through the primary term, without any secondary recovery, there'd be 25% of the original oil in place would be recovered. We believe that with the water flood unit in this area, we'd get that number up to 29% recovered. So this graph shows the lag time for putting together the unit and then the additional oil rates that would be recovered out of the secondary recovery unit. And based on those numbers, our economics show that it is definitely economic to invest in this unitization. And I'm talking very fast. The next big issue with unitizing an area is what the tract allocation factors look like. So with the 4 tracts, Foundation weighted the hydrocarbon pore volume, acreage, remaining oil, and remaining gas. And they did this determination with the idea in mind of balancing the royalty payments before unitization and after unitization. Foundation took over this field in 2012. And so based on their numbers from 2012 to current, they tried to balance those factors so that the royalty owners would have similar royalty rates after unitization. Again, with the goal to keep the royalty payments as consistent as possible. There are 3 major mineral owners, royalty owners in this unit, and we have been in touch with almost all of them. And we, upon approval of this, hope to have no problem getting 80% ratification by them. So we've included in this presentation a decline curve for all of the wells that were in the unit. Again, this is not my area of expertise, but this is the well that we plan to convert to an injection well. And I will go through these quickly for you. So we did it by tract. This well was plugged and abandoned. It had the last recorded production was in 2006, and this is in tract 2.
Could you entertain a question?
Yes.
Very quickly, do you have, because I'm assuming that's oil and gas production that you're showing on that?
Correct. Yes.
Do you have the water production?
I'm going to have to ask the foundation.
Not on this graph. But you do have it?
We can get it to you, yeah.
I was just curious about sort of on the proposed injection wells, sort of how much it made total liquid production on, you know.
You want to come up and speak to it?
We may have that data from the time we took over operations. Don't really have much of that data prior to the point of Foundation taking over operations.
Okay. It's just the context of the question is just a little bit of a concern about injectivity in the well and its capability to take what you proposed for injection rate.
If you're looking for how much water we can get out and then re-inject.
Not so much that, it's how much you can inject into the well itself.
Into the well itself.
Yeah.
We can certainly get something to you. So for tract 3, there's another well that was plugged in and abandoned in this tract. And then tract 4, we have a producing well and a plugged in and abandoned well in this tract as well. And I believe in our application, we noted that there was definitely some communication between the 3 producing wells, which also made this a good injection field. And the final part to the unit, to our request, was including a unit agreement and unit operating agreement. The operating agreement will generally be between the foundation partners, and we have satisfied, we believe, all of the requirements in the statute in 3461.18. And again, upon approval of the commission, we'll get our Form 33 injection well permit and approval by all of the royalty owners, and then submit that to the commission before we start operations. So any questions for likely the experts?
Any questions?
I have another one. Or could you go back to just one of the maps that showed all the various wells?
Sure.
Okay, so just curious, the wells that are just outside the unit, I guess on this would be to the northwest. It's like the Frank and the Foster. Is there any descend in those wells from the logs?
I believe the Frank well was a dry hole, and I don't know about the other outstanding wells.
Yeah, the Foster 14-2 had 12 feet of sand.
It did?
Yeah.
Was it tested or was it wet, or do you know?
Yeah, it's been drilled. It's, I believe the Form 6 has been submitted.
Adam, do you want to?
Yeah, it was drilled and it's produced, and I believe the Form 6 has been submitted to plug and abandon the well.
I'm worried about, I mean, you've mapped out sort of where you think your pay may be, but you have sand that occurs outside of the unit, so potential loss of injection water, either down dip. So you went through that pretty quickly. I wasn't sure if that was, if there was a structure map in there or not.
I believe there was.
There is, yes. Let's see.
Yes,
So, come on, Meredith.
I'll try not to dig into the technical geek stuff here too much, but.
Just bring everybody up.
This is Meredith Smith. She's a geologist with Foundation.
Hi. Do we need to swear the witnesses?
Just go ahead, if you don't mind, introduce yourself and your expertise.
My name is Meredith Smith. I'm a geologist for Foundation Energy. And no, did you want my qualifications?
No,
All right.
we assume you're very qualified.
Okay. Basically, we see at the BAB 1414 location, we see a thinning there. So we see a thinning in conjunction with pressure data. We don't see that the Foster 14-2 would be in the same reservoir.
Don't think they're connected?
No.
And
also our volumetrics tend to support this reservoir size.
Typical D channel?
Yes.
Any seismic across it?
We do have some seismic across this. I haven't found it particularly meaningful in saying anything about this,
Just
the
old 2D?
stratigraphy of.
It's old 2D data or?
It's, no, I don't think it's 2D data. I think it's 3D data to kind of show the Niobrara potential.
Okay.
So it should,
Be hard to pick, probably not processed so you could see the descend very well.
It was definitely not processed for that.
Okay, all right. I mean, go for it. It's just a few concerns, but I don't want to take up the commission's time with.
I think we're all done with our presentation.
Okay.
Excuse my ignorance, is there any potential, is the water pressure sufficient in the depth? Cause you any concern about increased seismic activity? You ever cause any earthquakes?
No.
It's a good question. I don't
think so.
I don't
hear you
think
say
so.
that.
I
You'd have
don't
to
think
inject,
so.
you have to inject above the frac gradient and you're not going to do
Sure,
that. So I did have a question about wellbore integrity when you went through the discussion with the staff about the quality of the wellbores and how they're cased and cemented and bond logs, et cetera, because I don't know about, I mean, these aren't really old wells, so they're probably in pretty good shape and probably have a surface casing is set plenty deep, but I guess that'd be more of a question for staff if they could say that they're satisfied with wellbore integrity.
That's not, oh, sorry.
I mean, you can answer it also, but.
Mr. Rouse,
Yes.
could you address the commissioner's question about wellbore integrity?
Yeah.
All I can say is staff engineers have looked at this and they're fine with it. And if there's going to be any permit issue, that will be reviewed at that time, see if there's a problem with it.
All right, thank you.
Okay. Any other questions? What's your desire relative to this docket?
I would move for approval.
Have a motion to approve
Second.
and a second. Any further discussion? Hearing none. All those in favor indicate by saying aye. Opposed, same sign. Docket 150700376 stands approved. Thank you very much for a good presentation. Well done. Okay, dockets. Oh, my goodness. There's several dockets listed there from SWN Production Company. And Mr. Jewell, I believe, is the, I think I saw him. Oh, there we go. Okay, Ms. Dorancy, we're ready for you to tee us up.
Thank you very much. This matter comes before the commission for two reasons. First, this is a request to vacate 4 unconventional resource units established in March of 2013 and October 2013. By order numbers 540-25, 540-26, 540-29, and 540-31 for the production of oil, gas, and associated hydrocarbons from the Mancos and Niobrara formations, as well as their associated pooling orders 540-36, 540-37, 540-42, and 540-46. This matter also comes before you for a review of the remaining unconventional resource units established in October 2013 and March of 2013. There are a total of 18 unconventional resource units now owned by Southwest Energy, including the 4 scheduled to be vacated today. SWN has prepared a presentation for your consideration. That'll be by Michael Jewell, and he'll also present his staff or his Southwestern Energy if necessary.
Thank you, Jill. Good afternoon, commissioners. I'm Michael Jewell from Burns, Figa, and Will, here on behalf of SWN Production Company this afternoon.
Bryce Moore, I'm a senior landman at Southwestern Energy.
Mr. Chair, if I can take a brief moment to say thank you to the director and his staff for their capable and professional assistance through this matter, and also to Mr. Rollins Family Investment and family for coming out today and being so patient to get to this point. So we're here with our 6th month, it's been about 9 though, given scheduling issues, report on these URUs. Before we go any further, you don't need to entertain all the fine print other than to say we are making some representations here, none of which that are suitable for your investment opportunities.
There was a word in the 3rd line.
Oh, you caught it. As a reference map, here we are in San Wash Basin, Northwest Colorado, in Moffett and Routt counties. SWN Production Company acquired these acreage positions through acquisitions with Quicksilver, Sweppy, and Axia, which is about 67,000 acres of the total 380,000 acre acquisition. It includes a number of federal and state lands as well, which I'll discuss in some detail. As a quick review, if you're really sharp, you might remember this is a slide from last time as well, but from December, we represented to you that 2015 will mostly be a study year, largely because we were taking all this acreage from the different sources and trying to unify one play. As many of you who might be familiar with the history of the San Wash, the geology seems great, but yet no one has been successful yet in cracking the code, and SWN wants to be the one that does it. So we're trying to put together all the knowledge that we can amidst low commodity prices, unfortunately. But however, recognizing the obligations we have not only to the mineral owners inside the URUs, but also obligations that we acquired to the state of Colorado and the federal government. So today our formal request is for you to terminate 4 of the 18 URUs. In our previous discussions, we understood the concerns about the implied need to drill out these URUs, and therefore it only makes sense that if my client does not see the immediate use for them, that we will make that good faith offer to terminate the ones that we believe are safe to do so. So we have these 4 up for your consideration. I believe they're in your information packet. Also, SWN has been in contact, the local land team is in discussions with their senior landmen and senior management staff as far as giving some more careful consideration to 7 of these URUs that have no permits in them as of now. And those will be under first consideration for any future potential terminations that could possibly come before you before the end of the year or whenever this next report would be scheduled. And in the meantime, we do intend to continue to cooperate with the protesting parties, and I will speak for myself, but I believe I speak for Ms. Bargel and the Rollins family as well. We've established a pretty good and clear relationship, so I appreciated working with them thus far. Quick discussion on our working interest position. We had provided, upon request from the permitting department, all of our known working interest positions in the remaining 13 URUs. And we want to demonstrate that 70% or more, I would call a supermajority, are in 4 of these URUs where SWN has 70% or more, where SWN has working interest 50 to 69.9 or 5, and minority interest will be in the remaining 4 URUs. So without getting into any specific details on individual URU, I think the inverse order would indicate those that would be slated for termination, and then downward order as far as ones that might be considered most profitable. We also want to give a quick note to the status of the Bulldog 2241 vertical 890 well. This indeed has been paid as a leasehold basis both before SWN's acquisition. Axial is paying that on a leasehold level, is doing so right now, and does not intend for this well to keep 4 square miles of URU. So in addition to these 4 terminations, we want to offer to you, and in step with our December discussion, we will anticipate coming back to you at a later date. And at that time, we hope to have a more thorough drill plan. We're knocking on wood. Commodities prices will cooperate. We do anticipate a considerable amount of well data to come in that's going to help illuminate the best places to drill moving forward. And so by that time, and working in harmony with the protesting parties, we will have a drill plan and or more terminations for you at that time. So we are making sure we live to our promise as far as our commitment to the resource, the mineral owner, and to maintain clear communications with the COGCC. And that plan will also address the 1 URU that does have an existing horizontal well, and our plans with the Rollins families how to develop that further. So unless you have any questions, that is the report we have at this time. Thank you.
Questions?
One quick one.
Commissioner Benton, one quick question.
The status of the Bulldog 2241V, that's a vertical well, correct?
Yes, sir.
Thank you.
The question was raised as whether or not we thought that was holding an entire URU, and no, we do not.
I heard that part.
Yes, sir.
Ms. Cindy?
Commissioners, if I might just take 2 minutes of your time.
Take 2.5. Hey, we got.
And I'll ask Mr. Rollins. My name's Cindy Bargel. I'm with Dasani Bargel. I represent the Rollins family. Mr. Rollins spoke eloquently this morning, and thanks to modern technology, I heard it all. So I'm not going to repeat what he said about working together and that we've appreciated the commission's work on these URUs. I would say that had the commissioners not had the foresight to review these 18 URUs that were established 2.5 years ago, of which only 2 have been drilled, these would be lost somewhere, I think, in the process. So we very much appreciate the chance for you to look at these again. There are places where unconventional resource units have worked in an amazing fashion, and the wells have all been drilled out. Unfortunately, I think as Mr. Joel said, the code has not yet been cracked, and my client understands that in the Sandwash Basin. We also realize that only 2 of those have been drilled, and we know that the commission has brought to the attention of SWN, which I think I'm saying that right, Swin, that there are 7 URUs that may be due to be vacated. And the concern, because the real question is why, who cares? You know, why do we need to look at these, or why should we even consider vacating them? And the real concern is they're pooled. And so that if there's leasehold acreage that expires, as to say, for instance, those 4 URUs in which Swin only owns a 50% interest, there are parties out there that have open interest now, where if I wanted to go lease them, which I personally would not, but I mean, if an operating company would want to go lease them and drill, they would be subject to a pooling order that exists that encompasses 4 sections. And so it muddies the waters for some of these mineral interest owners. And that's really why I'm here, is how do we keep the waters clear on these issues? And I think the continued review is part of it. We would advocate again for exploratory URUs, that probably some process in place, and I think it's even evolving as we speak, that you don't approve them unless there's a permit. If the permit expires, then should they expire within a certain period of time? There are policies and processes that I think would go along with exploratory URUs that are important for the commission to consider. And I don't think the Rollins family is going to change their tune on that, because you've heard it several times, and I agree clearly. The other thing I'm happy to hear said is that by the December meeting, there will be a proposal in place made for the Bulldog, the single horizontal well, on how is that going to be drilled out? How's that going to be developed? Or is it not going to be developed because commodity prices are such? In any case, it's fair to know what's going to happen with that URU. And then with respect to the single vertical well, and I think it's important for everyone to consider, if that URU was established and it holds section 16, but there's still a pooling order in place that comprises a whole 2,560 or 80 acres, what is the impact of that? I mean, does the pooling, would people not go in and lease? And I don't have the answers for you, but you have a vertical well holding a section that's surrounded by a pooled area. And what are the impacts of that? So that's something to consider for the future. Again, we appreciate your time. We appreciate your persistent review of these, because they are something new. And I apologize, I wasn't here earlier, and I appreciate the opportunity to speak now. And seeing a nod no, that was probably 3 minutes. I'm sorry.
You're right. Thank you very much. Any questions for these folks? Okay. Sir.
Mr. Chairman, I think that the way this has been teed up, we do need commission action on the proposal to terminate 4 of the URUs.
Correct.
So moved.
Motion and a second to terminate the 4 URUs listed. Any discussion? All those in favor indicate by saying aye.
Aye.
Opposed, same sign. They're terminated.
Thank you.
At least as far as this commission is concerned. Okay, thank you.
And just for the record, we'll have another review in December of 2015 on the remaining URUs.
Thank you, Jill. Thank you, Mr. President.
Thank you.
Chances are good we'll be here to hear it. Okay, next item, docket 150500158, Merrilex Resources. We have Greta Beckstead, Assistant Attorney General, and Jeremy Farron, our Enforcement Officer.
I'd like to take to it. Mr. Chairman, if I may. Black Hills Exploration Production has business dealings with Merrilex as a partner in some of our wells, so I would like to recuse myself from this particular matter.
Duly noted. Ms. Murphy will note that for the record. Director?
And Mr. Chairman, if you recall in the May hearing, Mr. Randall participated instead of Commissioner King. And for that reason, Mr. Randall has returned quite timely to continue hearing this Merrilex matter, and Mr. King has executed.
Lucky man.
Exited.
Commissioner Walk, don't take any, don't get any ideas from this.
I want to know how you swing this kind of deal.
Yes. I was visiting Saturday with former Senator Jim Isgar, who was the Senate carrier of the bill that formed this new commission. He did not anticipate having Mr. Randall here. I don't know if you remember that argument.
I do, Mr. Chair.
And for those interested, Mr. Isgar is doing relatively well. You are listed first, so I'm assuming you.
Okay, that's odd.
That's a little eerie.
Or else.
The crowd goes by.
We're good?
Yeah.
All right, testing. Good afternoon, Commissioners. Britta Beckstead, Counsel for Commission Staff, and docket number 1505-00158. It's a pleasure here to be speaking with you about the Rifle Walton 25-2 well, again, late on a Monday afternoon, and hopefully we'll keep this to the point and lively. This case was partially addressed by this commission at the May 18, 2015 hearing. Order 1V509 was entered as a result of that hearing, which found Marilex Resources in violation of Order 11285, Rule 317E, and Rule 605B7, and imposed a penalty of $52,500. Before we get into the issues that were not decided in May, the parties would ask the Commission to vote on amended Order 1V509. This proposed order is in your portfolios at Bates numbered pages 5 through 8. The amended order, which is supported and agreed to by both parties, accommodates a payment plan over 4 quarters and waives Marilex's right to appeal the order. Both parties respectfully request that you approve this amended order. And William Zimsky will now speak on behalf of Marilex Resources in support of it.
Would you tell me the Bates page again, please?
Sure, page 5 to 8.
William Zimsky on behalf of Marilex Resources. And we have reviewed the amended proposed order and we're in agreement with it with the payment schedule. And we worked together with staff, with Brenda, and it's acceptable to us.
Okay, thank you. Is that action we need to take right now?
That would be agreeable to the parties.
Commissioners?
So moved.
We have a motion and a second to approve that order. Any discussion? Hearing none. All those in favor indicate by saying aye.
Aye.
This must be a big folder. It's taking some time. Okay, that stands approved. Oh, thank you for that.
Okay. Turning to the issues at the Rifle Walton 25-2 well that were not decided in May. At the May hearing, the Commission directed Marilex to propose an alternative plan to stop the water flow at the well and reserve judgment on the issue of liability and penalty for the alleged Rule 319B1 violation. As a result, there are 2 remaining issues for you to decide today. First, whether Marilex violated Rule 319B1 by failing to perform a successful mechanical integrity test prior to temporary abandonment. And second, whether Marilex's proposal will stop the water flow, and if not, whether to require Marilex to implement staff's remediation plan. Today, I'll briefly introduce these issues, and then Marilex will present its proposal. Stuart Ellsworth, Engineering Manager, and Craig Berger, Northwest Engineer, will then present staff's response. Issue number 1, the Rule 319B1 violation. Both staff and Marilex presented argument, evidence, and testimony on this issue in May, and I will not rehash all of it here. But as a brief reminder, Rule 319 requires staff approval and a successful MIT before an operator may temporarily abandon a well. Here, the separator was removed from at least November 7, 2014 to February 26, 2015. During that time, the well was temporarily abandoned according to the 100 series definition. Merrilex has argued that it never intended to temporarily abandon the well, but why the separator was removed is irrelevant to a determination of whether Rule 319 was violated. If the separator was removed without prior approval or a successful MIT, Rule 319 was violated. Staff was requesting a penalty of $47,600 for this violation, which lasted 111 days. Turning to the second issue, the remediation plan to stop the water flow. The Rifle Walton 25-2 well has an uncemented annulus from 309 feet to 5,120 feet. This wellbore diagram, which is staff's exhibit 14 and Bates numbered page 27, shows this existing condition. COGCC records reveal that the well has 7 to 13 barrels of water coming out of the annulus per day. Not only does this add up to a lot of water, but it also demonstrates a failure of wellbore integrity. The well lacks zonal isolation and is therefore a risk to public welfare and the environment. As expressed in staff's presentation and other materials at the May hearing, there are multiple sources for the Commission's authority to require operators to correct formation migration issues, including the one found at this well. These include Section 106 of the Act, Order 1107, and Rules 208, 209, 317, and 319. At the May hearing, the Commission determined that something had to be done about the well to stop the water flow without delay. Several commissioners identified this water flow as an issue of wellbore integrity and expressed concerns about allowing the water to continue to flow. To recap these discussions, here are a few audio clips from the May hearing. Brief audio clips, I will add.
Mr. Chairman, if I might start on this. Before we address the issue of the fines, I think we need to have just a little deliberation on what we think we need to do with the well that's flowing water. I'm not comfortable just letting the well flow water. And
All right, and the next one, discussing wellbore integrity.
That ties on with what Commissioner Hawkins said. In my humble opinion, this well lacks wellbore integrity, which is something that this commission has tried to go ahead and get a grip on throughout the state, because that's our credibility, is that wells maintain wellbore integrity. Maybe I'm missing something here, but
That's the MIT's, isn't it?
it's flowing on the backside and I can't shut that well in.
at some point, there's going to have to be a plan on how to shut the water off. And so we need to address that now. We can't just let that float, so to speak, forever.
I'm in agreement with you. I will support, if that happened to show up in a motion at some time, I will support it.
And the last one.
What I would think about is to give Marilex 30 days to propose an alternate water shutoff solution, and failing that, then to go with the staff's recommendation.
So now you guys all have the pleasure of hearing yourselves if you haven't listened to your hearings, which is fun. I'll tell you from listening to myself.
I'm never speaking again.
I know, right?
The transcripts that are a problem.
Yeah. Well, I hope that doesn't, put a chilling effect on deliberations. The commission ultimately decided to give Marilex one last opportunity to present an alternative plan to staff that would stop the water flow. Marilex's proposal, which was not submitted to staff until July 10th, is to continue to let the water flow for an undetermined time. This is precisely what the commission determined at the May hearing could not occur. This is a slide depicting pages 11 and 12 of Marilex's proposal, and you will see it contains words like monitor, analyze, test, and investigate. The only timeline that is provided is after long-term testing. Marilex has already had 4 years to monitor, study, and investigate this problem. It's time for a solution and not for additional study. Staff was very willing to have a dialogue with Marilex regarding the placement of the cement, the number of squeezes, or even another potential solution that would shut off the water within a reasonable time frame. However, such discussions were difficult when Marilex's position has been that the water can continue to flow and they can continue to study it for the foreseeable future. Marilex also repeatedly mentions the economics of performing any of the possible options as a justification for not completing them. Responsible development does not entail waiting to correct issues such as this, based on the fact that gas prices may or may not increase. This well has been uneconomic since 2012, even when gas prices were high. And as you can see on the slide, Marilex admits that even without performing the remediation, this well would reach its economic limit 2 years after its return to production, unless something drastic happens in the market. At what point will Marilex responsibly balance the risks associated with the integrity issue with the well's lack of production? Most importantly, Marilex's proposal has no hope of stopping the water flow within a reasonable time period. Staff asks that this commission reject Marilex's proposal as non-responsive to its directive and require Marilex to implement staff's remediation plan as the best possible solution to shut off the water. After Marilex presents its desire to maintain the status quo, Craig Berger will clarify why staff is concerned about the continued flow, explain where staff thinks the water is coming from, and demonstrate how staff's plan will work to shut off the flow. For a revised wellbore diagram showing staff's plan, I would direct you to Exhibit 15 and Bates numbered page 28, which is shown here on the slide. At the conclusion of this hearing, staff respectfully requests that this commission adopt staff's proposed order and find Marilex in violation of Rule 319B1, impose a penalty of $47,600 for this violation, and require Marilex to perform the annular flow remediation proposed by staff at the May hearing and again here today. Thank you.
Okay.
And now staff will turn it over to Marilex to present their proposal.
Good afternoon again, William Zimsky on behalf of Marilex. Very briefly, as staff counsel indicated, we already presented evidence about the temporary abandonment issue. I don't want to rehash that there. One of our biggest arguments is that it wasn't temporarily abandoned. It was capable of production. When you remove a separator off of a well site, doesn't necessarily mean it's not capable of production. There was testimony that it was. As to the assertion that Marilex had 4 years to monitor, investigate, and take care of this problem, for those 4 years, Marilex was doing exactly what the commission said, and there was no mandate or direction to stop the water flow. It was proceeding. It was being operated in conjunction with monitoring approved by the COGCC. And as far as the wellbore integrity, it did pass an MIT test. And when the commissioners, I think in the clip, was talking about the backside water, there's no migration issues regarding oil or gas or hydrocarbons going from any formation up to the surface. It's water, the source of which the commission admitted, staff admitted at the last hearing that they didn't know what the source of that water is. So the water is not migrating from a formation up to the surface from a known formation, because the commission staff can't pinpoint where the water is coming from. So therefore, Rule 319B1 does not apply. Now, our presentation will be mainly testimony from Mr. O'Hare of his reports, and that's found at page stamp number 9 through, I believe, 22, and I'll be asking questions. First, we're going to address the need for it to stop the flow and the staff's concerns. We're going to address that. Then we're going to talk about the plan that Marilex has. With that, I'd like to have Mr. O'Hare sworn in, or if he's continued to be sworn in for the last hearing.
You're
under oath from last
You're under oath.
Mr. O'Hare, could you briefly introduce yourself again to the commission?
Yes, excuse me. My name is Alexis Michael O'Hare. I go by Mickey. I'm the president of Marilex Resources.
And your background, very briefly.
I'm a petroleum engineer and have been a registered professional engineer in the state of Colorado for about a quarter of a century.
And how long have you owned and operated Marilex?
I've been the joint owner of Marilex for a little over 25 years.
And prior to that, did you work in the industry?
Yes, I've worked in the industry since about 1980, I guess.
Now, the staff has indicated that there's a need to shut off the water flow at the Braden Head. One of their concerns is possible erosion. Do you believe the staff's concerns are valid with respect to erosion?
No, if you just do the calculations from the flow of the water, we're talking about a very, very low flow rate. Certainly not anything that would ever erode any steel. The flow rates are so low that the potential for erosion is non-existent.
And that's set forth at pages 3 and 4 of the report, page 13 and 14.
That's correct. If you look at the flow rates calculated over a 1 foot interval, the influx of water coming into that well bore is less than 0.002 of a fluid ounce per second per square inch. If it's coming over a 10-foot thick zone, then it is less than 1/10,000th of a fluid ounce per second per square inch. Those are exceedingly low rates that would not erode even soil.
Now let's talk about corrosion concerns. The staff indicated they were concerned that the casing might be corroded by the water. Could you address that issue?
Yes, we had water samples collected and tested for corrosivity, and the Green Analytical Labs in Durango came back and said basically the water is non-corrosive.
And I remind the commission, there was testimony where I think the staff indicated it was very fresh water.
That is correct.
So that's in the record. Now there's, in the staff response to Marilex's proposal, on page 1 of that response, they talk about shallow casing leaks are a risk at this well. And they say the casing already developed a leak at 5,675 feet. Is there any reason that would lead somebody to conclude that there might be leaks at shallower levels?
No, if you look at the cement bond log that was run on April 1st of 2015, you will see that the site of the casing leak has some of the best cement bond in the well, and that's shown on this next exhibit.
And this is the cement bond log, which was exhibit 10 at the original hearing.
You can see that's very near 100% bond, both above and below the point of the leak. So there's no chance whatsoever that the water from the surface could have gotten down to this zone. And even if it had, it was non-corrosive and could not have been the source of that corrosion. But a good point to make here is that even though you have a good cement isolating a point in your casing, does not necessarily mean that your casing is protected from corrosion.
And the water may have caused that leak at 5675 feet?
Yes, it's possible. There's a water stand opposite that point in the casing that could have been responsible. It could have been a very brackish water that could have caused that leak.
Well, we have no testing of that water.
No, sir.
Now, let's talk about determining the source of the water. There was some discussion at the last hearing about methods of trying to locate exactly where the water is coming from. Can you discuss or explain to the commission why the difficulties in pinpointing the source of the water?
The staff suggested that both noise and/or temperature logs could be run to determine the source of the water. But with the very low flow rates that we're seeing from this well, neither one of those tools would detect water influx, especially at the rates that we calculated above. If you look at the velocity of the water, which is really what noise logs are trying to hear, as if you have a river running and it goes to a narrow spot, the noise of the water increases dramatically. So the noise logs are listening for the velocity of the water. But the velocity of the water in this well is so low, less than 16 thousandths of an inch per second, that noise logs are not likely to pick up that velocity or that water. And in the same way, the temperature logs are not likely to pick up a change in temperature from the flow of the water, because the water temperature is being changed by the formation temperature because it's moving so slowly up through the wellbore.
And so your velocity calculations are on page 5 of your report, and your discussions about the source of the water is pages 4 through 6. Is that correct?
Yes, sir.
Now, on page 6 of your report, you talk about fundamental flaws of the staff's solution. The first thing you talk about is cement will never have the same strength as steel casing. Can you explain that a bit?
Yes, steel casing, at least the casing that is in this wellbore, has a compressive strength of about 55,000 PSI. That's pounds per square inch. Even with the best cement, Class G neat cement with some strength enhancers, at best we can get up to about 5,000 PSI compressive strength. That compressive strength is less than 10% of the compressive strength of the steel of the casing. So in essence, you're saying, let's put holes, let's damage that casing and replace that compressive strength with something that is less than 10% of the strength. If you had a perfect world, that should be sufficient, but we don't have a perfect world. In fact, this wellbore that we'll talk about later has some very difficult primary cementing properties to it, and even more difficult secondary cementing properties, such that it's virtually impossible to guarantee a good secondary cement job here. So if you're compromising the integrity of your casing intentionally with the hope that you can fix it with 10% of the strength of what you have in there now, less than 10%, you're taking a huge risk. And I would dare to say it's a very dangerous risk, because you are exposing hydrocarbons to freshwater zones by doing that. Right now we can show through the next slide here that, that there are hydrocarbon zones above the places where they want to, the staff wants us to place the first plug. At roughly 1,650 feet to 1,708 feet, we have what looks to be a nice gas-bearing zone. According to the staff, this zone is exposed to the surface, and yet we have never seen any kind of gas flow to the surface. So it appears to us that we have some kind of seal above this gas zone that the staff has not taken into consideration. If we didn't, we should be seeing gas flowing from this zone to the surface mixed with the water that we're seeing at the surface. That has never been documented. We've tested at the mandate of the state on a number of occasions and have never had any measurable gas to surface.
Now, in their staff response on page 2, they talk about cement v. steel. they state the compressive strength of cement continues to build for years after the initial set. Do you have any opinion as to that statement?
Yes, sir. Talking to the cementing experts at Halliburton, there is a hyperbolic increase in the strength of cement, which means that it starts at a very low strength and increases very rapidly and then levels out over time. So it may be still increasing over time, but it's a very, very minute increase. So if you look at the numbers, generally speaking, the cementing experts say that their test results obtain their ultimate strength of their cement in 72 hours. Anything over that, they wouldn't even commit to a 10% increase in strength over years of time. So the 5,000 PSI ultimate strength or maximum compressive strength of the cement is virtually all you get, and you get it in the first 72 hours.
Okay, and now can you discuss if you did the cement job and the squeeze job as recommended by the staff, is there any guarantee that that would work?
No, in fact, if you look at our next set of slides here, there's a fairly good guarantee that it will not work. A number of variables have to be looked at, a number of characteristics have to be looked at to determine the potential success of a primary cement job, but even more importantly, a secondary cement job. If you look at the wellbore configuration, that's very important, because if you have a very large wellbore with relatively small casing, your chances of getting cement around your casing are very slim, especially if you have any deviation in the hole. That is further exacerbated by the problem of old mud being in the hole on a secondary cement job. This well is more than 34 years old, so that mud has been sitting there for 34 years dehydrating. Again, the Halliburton cementing experts tell me the most difficult thing about any cement job is removing the mud so that you can get a good seal with your cement. In a primary job, you have much better chance of doing that because your mud is fresh, you can move your pipe, you can use tools on the casing, and you can use certain scrubs and washes ahead of the cement to remove that liquid mud. Once that mud has solidified, has been dehydrated over years and even decades, you have a much, much less chance of removing that mud from the wellbore, that dehydrated mud. And so you get channeling. That channeling gets worse if you have any deviation in your hole. Your pipe will be laying, your hole will be laying to one side, and generally your pipe is installed in tension. So that pulls the pipe up against the top of the hole. That allows the cement to run along the bottom of the hole and channel up one side of the hole. So you're not sealing all the way around your pipe, and that's what's called channeling. That channeling gives you a way for your hydrocarbons, your gas under high pressure, to follow the casing up to the surface or to whatever holes you were not able to successfully squeeze off with your cement.
And the Exhibit 17 by the staff, they had 2 remediation plans for 2 wells. The fact that they were originally spud in 2014, does that make any difference as an analog to, whether your squeeze would be successful?
Absolutely, it makes a huge difference. It's like comparing apples to eggshells. What you're looking at there is relatively fresh mud in those new wells, 1 year old or less, compared to dehydrated mud that has been sitting in there baking away for the last 34 years.
And then the staff also points out that you were successfully squeezed perforations twice on this well. Can you explain why those were successful?
Sure, we can go back to this first exhibit here, and you can see the squeeze that we performed on the leaks here were surrounded by good cement bond. The original primary cement job was very effective in this area. And so what we squeezed into that leak was less than 1.5 barrels of cement, and it squeezed off the zone that was not protected by the existing cement. That's totally different than what we have for the situation that we're talking about up hole in this particular well. With that, uncemented, or at least not properly cemented section that they want us to squeeze cement in, the chances of getting a good seal around our pipe are almost nil. Talking to the Halliburton cementing experts, I asked if there was any new materials that they have been experimenting with that would be effective in removing the dehydrated mud. He said they've tried everything from very basic materials to very acidic materials, and so far they are without success.
Now, in the staff's remediation plan, top of page 2, they list their various intervals, and they indicate these depths were carefully selected to target relatively impermeable shale zones based on the induction log in order to prevent loss of cement and fluid flow into more permeable sandstones. Based on the induction log, which is Exhibit 3, do you agree with that assertion?
No, there's several sands in those intervals that they have proposed to cement.
And so that would mean, what if there were sands in those intervals, what would happen?
It's likely that cement could be lost into those intervals.
Now, another concern they have is the formation breakdown of the surface casing. And that's on page 1 of their response to your proposal. How long was this well shut in for?
We believe that the Braden head had been shut in for close to 30 years before it was first tested.
And so how does that impact upon the staff's concerns?
Well, the pressure didn't just magically appear when we opened the Braden head for the first time. That pressure had to have been there for the last 30 years. So if there had been a risk of breaking down the shoe, it happened a long, long, long time ago.
Okay, and let's talk about your Merrillex's proposal. Can you discuss that? That's at your plan. Starting on page 9, talk about other options, but let's go directly to the plan, which is pages 11 and 12. Can you explain the plan to the commission?
As the commission is obviously aware, our number one concern is to make sure that hydrocarbons do not come in contact with this freshwater flow. We think that there is very little possibility of that happening based on what we've seen for the last 34 years. That possibility could still occur through internal corrosion of our casing. And so what we would propose, in addition to monitoring the fluid flow, is to make sure that we're treating internally our casing on a regular basis to make sure that there is no internal corrosion occurring with that pipe. So that really is the purpose of the first 2 points of the plan, is to make sure that we don't have any possibility of our hydrocarbon producing zones from communicating the freshwater zone that is currently flowing out the Braden head. And we would maintain that that will help protect the health and safety of the public as well as the environment. But in order to do that, another need for the well is to make it economic. And so what we would propose is a number of different procedures. One would be to install compression on the well or on our gathering system to be able to pull down our sales line. The staff has indicated that the well has not been economic for a number of years. The staff does not seem to realize that we have a 900-pound sales line that we're trying to flow into from this well. And that makes it very difficult to get economic flow out of the wellbore. So we are looking into acquiring or renting compression to be able to draw that sales line pressure down and increase the flow from the wellbore. That increases the economics of the well, and it gives us the ability to look at other options for it. I've spoken to the landowner on a number of occasions now. He has indicated that there has been seeps and springs on his property from the day that he bought it. It's not unique to our well. He says there's been one close to our well location since he first purchased the land, and he is happy to allow us to go in there and test that spring and to see what happens when we shut in the Braden head. If the flow from that spring increases and it doesn't increase dramatically and cause washouts or erosion on the surface, then it may allow us to go ahead and squeeze off the flow at the Braden Head without damaging the environment. But we need to do that kind of testing with cooperation of the state for us to be able to determine what kind of impact it would have on the environment. I want to point out that this is fresh water. It's not something that is going to have a negative impact on the health and safety of the public, even if it does increase the flow. But we would want to be careful as to what is done with that flow. You know, do we need to build a pond to catch it and then work with the landowner to use it for irrigation or for livestock watering or other purposes that he has indicated might be useful to him?
Does that summarize your proposal to the commission on how to deal with this?
Yes. Let's go back to that. I'd like to call your attention to this slide and just point out when we perforate the casing and we try to squeeze that cement through those perforations, generally we'll have up to a ½ inch hole in that pipe, and they're at 90-degree angles from one another, and they're over a 1-foot interval. And generally when you pump cement or any fluid down the casing, it's going to come out that first hole first, okay? Provided that that hole is not up against a wall or a thick mud cake that it can't get the fluid through. But if that is open and it's in an area where it can flow, that cement will go out that first hole and start heading up the hole. If we don't increase the pressure significantly, cement will not get down to those other 3 holes. So we will increase the pressure and the rate as much as we can to try to force the cement through those other 3 holes. But like I said, if even one of them has a thick mud cake dried out, or it's against the wellbore, the wall of the wellbore, and fluid cannot get out of it, then we don't cement off that hole. So when we get in there and we drill out our cement, we do a pressure test, we might be able to get up to 500 pounds pressure on there without seeing any loss of pressure. The danger is if you leave that perforation in that condition and it's not properly sealed with good, hard, thick cement behind it, and then you shut your well in and let that pressure build up to 2,300 pounds, that's when you can see the communication out that hole into that annulus, go up into the water, the freshwater zone that is flowing now, and contaminate that zone, okay? So that's why I say the staff's recommendation, number 1, hasn't shown a need for the perforating and the cementing, but number 2, much more dangerously, could cause the very thing that they claim they're trying to prevent. And we cannot, as a little company, take on the kind of liability that the staff is trying to force on us through their mandate or through their recommended plan.
And, that's our presentation. I think I have a couple minutes left.
Or just almost 5.
Hello, this is Stuart Ellsworth, the engineering manager here at the commission. I just want to point out that that Mr. O'Hare has really presented how complex the oil and gas industry is, and It's not an easy business. There are some very complicated and difficult things that one has to do to maintain wellbore integrity. And that's our role at the commission, is to maintain wellbore integrity. Our 317 rule says all fluids need to stay, I'm a bit paraphrasing, but all fluids need to stay in their formation of origin. That means hydrocarbons, that means water, that means gas, that means all fluids have to stay in their formation of origin. This particular well, that's not the case. We define that as not having wellbore integrity. Craig Berger has been evaluating this well for quite a while under my supervision, also the supervision of his supervisor, Dave Andrews. So he has the technical knowledge about this individual well, and I'm going to pass it over to Craig.
Commissioners, at any point, please stop us if you have any questions. Mr. Berger, could you introduce yourself for the commission?
Yeah, my name is Craig Berger. I'm a professional engineer. I'm working with the Colorado Oil and Gas Commission in the Northwest area as an area engineer.
This is Staff's Exhibit 14, Bates page 27. Could you describe what is currently happening downhole at the well using this diagram?
Well, I can describe what we know. This well has a surface casing set at about 309 feet, and top of cement we have called it 5,120 feet, although Marilex seems to disagree. The Mesa Verde top is about 2,661 feet in this well, and so we believe there's uncemented annulus all the way up to 309 feet through the Wasatch Formation, resulting in a lack of zonal integrity or zonal isolation between the Mesa Verde and Wasatch. In the Wasatch, there are several potential water sand formations. The only one being used right now for drinking water in the area is what we call the Upper Wasatch, down to a depth of about 400 feet or so, which is at an elevation below the surface casing setting depth in this well. When the Braden head is closed in, pressure builds high enough to break down the formation at the surface casing shoe. So the current condition of approval on this well is that the Braden head be kept at a pressure of less than 55 PSI.
So are groundwater formations potentially commingling at the well?
Yes, based on what we know, there is potential commingling of different waters in the Wasatch and potentially Mesa Verde that may have different salinities. One potential problem with this is that the salinity from the deeper formations is generally higher than in the shallow formations. And so the salinity could be increasing in the shallow formations due to an influx of water from the deeper formations that has a higher salinity.
Is it also possible that currently oil and gas could also be commingling with those formations?
Yes, it appears so. Mr. O'Hare had a portion of the neutron log, I believe it was, from this well that showed potential gas up in the 1,600 foot range. And that was back from 1981, so it's possible that that gas already moved to a different zone, although there could be small amounts of it moving at this time. No, we just don't know.
And about how much water is flowing out of the Braden head currently?
Well, it's 7 to 13 barrels of water per day. If you use the 9 barrels of water per day, that comes out to be about 0.42 acre feet per year for the agricultural folks.
Go ahead, if you don't mind, speak loudly into that microphone
Okay.
for the people in Quebec or wherever.
Okay, sorry. It's about 0.4 acre feet per year coming out of the Braden head.
And about how much is that in practical terms?
Well, that's probably about the amount that a family of 4 would use for domestic use in a year.
Does COGCC typically permit water wells?
No, we are not involved in water well permitting.
This is staff's exhibit 16, which is Bates numbered page 29. Mr. Berger, could you describe what this diagram shows?
Yeah, this diagram's meant to show one possible scenario or probable scenario. It's not proven. Probably, this is a kind of a standard artesian flow diagram from a lot of basic hydrology textbooks where you have some deeper water, some shallower water, and then another formation of water. This is how artesian flow happens, is you have the hydraulic head is higher than the elevation of the well, so that water just comes flowing out. You don't have to pump it. In the case of this well, it's quite possible that some of these formations are commingling with each other.
What's a non-flowing artesian well?
Well, yeah, artesian wells flow under atmospheric pressure. You could close them and they wouldn't flow.
It's just got overburden.
Yeah, and these water formations underground, the hydraulic head is not sufficient to push the water up to the ground surface. In the artesian wells, it is sufficient pressure to push it out once you open it at the tap.
And does this pressure mean that the well could be oxygenated?
Yeah, it's possible that there could be oxygen in the water, which could, even though the water is fairly fresh, increase the potential for corrosion of a steel casing underground. We don't know the answer to that because Marilex did not submit the recent water testing results with their information they submitted.
Okay, turning now to staff's plan, which is exhibit 15, Bates numbered page 28. Can you describe staff's proposed remediation procedure using this diagram?
Yes, our proposed procedure based on the information we have, and we were hoping for an operator alternative that would work, would be to place at least 100 feet of cement in the annulus above the Mesa Verde to isolate the Mesa Verde water from the Wasatch water, and place another 100 feet in the annulus, about 800 or 900 feet, to provide some well control in case some pressure got past this lower plug, and to separate some of this more brackish water in the middle Wasatch from what we think might be fresh water in the upper Wasatch. And we know some of that hydrology and water information from some studies that have been done in the area.
And how did you choose these cement placement locations?
Yeah, basically the only information we had for this well was the induction log, and we looked for shaly layers where the cement tends to set up a little better and not be lost into porous sandy formations. Based on the information we have, that's how we selected this.
And have perfs and squeezes been used at the Rifle Walton 25-2 well already?
Yes, as discussed a little bit before, this well originally in 1981, when it was first completed, it had perforations in the causette. Those were abandoned probably because they were producing too much water. So the cement was squeezed into those perforations in the casing. And although there was slightly different than, as Mr. O'Hare pointed out, slightly different than up the hole, because there was existing cement in the annulus probably. But that cement was squeezed into those holes in 1983, and that has still passed that casing integrity test this year. And then the other hole in the casing that was squeezed was also talked about up there at the 5,600 foot depth that Marilex detected when we ordered a mechanical integrity test this last year.
And this is staff's exhibit 17, Bates number page 39. Have you reviewed other wells where other operators have volunteered to perform similar remediation?
Yes, here's an example. I know of 15 Bradenhead remediations that have been performed to decrease the pressure or stop the flow of water at the surface. In this Mam Creek notice to operators area, the commission order was, I believe that was a 2004 commission order. Here's an example is a well that was remediated by perforating holes in the casing and squeezing cement. And as Marilex did point out, Mr. Hare did point out that this is a newer well, so there are slightly different conditions downhole. But this was a brand new casing, and the operators wouldn't perforate a brand new casing unless they were fairly sure it would work.
And can you distinguish the well that Maralex mentions in its proposal where the perforation and squeeze was not successful? It was on page 7.
Yeah, Maralex discusses a perforation squeeze job that did not work the first time around. That was on a horizontal well being drilled northwest of DeBeck, and that was on the intermediate string, which is the string that provides zonal isolation. The operator pumped their primary cement job, lost some cement into some formations down there somewhere, did not get the top of cement they wanted. So they went in voluntarily, perforated their casing, their intermediate casing, and squeezed cement into it. Cement job apparently didn't hold the first time or the second time around, so they may still be working on it.
Okay. Can you address the concerns about the compressive strength of cement that Mr. O'Hare brought up?
Yeah, I'm not going to go too deep into cement, but it does reach a certain strength at 72 hours and then does increase in strength after that. So, to say that cement 20 years from now is not going to be as strong as it is next week it's not really a correct statement. So if you can get your cement in there, get it to set, get it to hold pressure, it should be adequate for years to come. And that's, one thing operators frequently pump cement into holes and then drill out the cement and then walk away assuming it will hold after they do their pressure test. So to to say, oh, it's really dangerous to put cement down the hole and do a perforation is not the whole story.
Will Maralex's proposal work to shut off the water flow, in your opinion?
No, this is Maralex's proposal will not shut off the water flow.
And do you agree with Maralex's engineering analysis?
I disagree with portions of it.
And why is further study unnecessary at the well?
Let me get my notes here. I'll cheat. Well, this water flow has been occurring for about 4 years now. So we know that this isn't an isolated sand lens down in the ground that's going to eventually stop flowing water. It looks like it's going to continue for another 4 years if allowed to. So the pressure basically has not blown down, and it doesn't appear that it will. We discussed some of the environmental risks. There could be commingling of the water going on down there. We don't know. The operator has not made an effort to locate the source of this water.
And thank you. That's all we have. If you do not have any questions.
Any questions? Has the water flowing out been tested as to TDS, salinity, carbon dioxide, whatever?
Our files have one sample analysis from 2011.
And?
Well, we presented that at the last hearing. I can't remember if that.
I can't remember when we had the last hearing, let alone.
1,600 parts per million total dissolved solids, which puts it in the EPA classified underground source of drinking water category.
Mr. Berger, I neglected to remind you that you were under oath from the last hearing. I suspect Mr. Zimsky has some cross for you, and I just want you to keep that in mind.
Yes, sir.
Mr. Chairman, or
We'll see if any of these astute folks have a question.
I'm kind of stumped here because I do have a 100% requirement here, and that's wellbore integrity, and that's Rule 317. So somehow that water flow has got to stop. Black, white, flowing up the backside. There's zero chance that I'm going to continue, that I'm going to go for that. Now, you've just said what they proposed is unacceptable to you. Well, what are you going to do with that well so I meet the requirement of 317? It's got to have wellbore integrity, and if you can't maintain wellbore integrity, well, P&A is coming in my head. So I need a solution. If you don't like theirs, you got to figure out one, and there can't be any flow to the surface. And there can't be any suspected cross flow in between zones. So I'm stuck. I'm looking for a solution because right now P&A is the only thing that's the only thing I'm seeing.
What we have suggested is a braiding head squeeze that would shut off the water and keep it from flowing out of the surface. We would recommend that there be some testing done before that happens so we know the results of that squeeze. If we shut off the water from the braiding head from the top, what does that do to the existing springs and seeps in the area? So our recommendation is to monitor, test, find out what the outcome will be before we pump the cement down the wellbore.
But even if we cement squeeze from the top, okay, we still have 4 zones that are open behind pipe in this well.
Again, we don't believe they're open. If they were open, we would have seen gas to the surface. The fact that we have never seen gas to the surface indicates that there is some kind of seal above 1,650 feet. Otherwise, we would have seen gas. We would still be seeing gas.
But you could be having flow between zones and still have a seal that would prevent it from coming up to the surface.
That is a possibility. We don't know that it's not happening. We can't prove that it is happening. So I can't stand here and say, no, it's not happening because I can't prove that.
Well, I think that's the concern of the commissioners, at least from my point of view, is that we want to make sure that we maintain isolation of the zones and, prevent uncontrolled flow.
We believe that at least the zones that the staff is indicating there is cross flow in is not happening because we don't see that gas to the surface. We don't see it coming out in that fresh water. We have done multiple tests on that water. I was sure that we had submitted the latest one to the staff, but they're claiming they don't have it, showing that that is drinking water. It is very fresh water. Okay, if it's coming from a hydrocarbon producing zone, it's not fresh water. Almost never do you see fresh water from a hydrocarbon producing zone. So there is no communication indicated with all the information we have between hydrocarbon producing or potential producing zones and freshwater zones at this well. There is no indication of that whatsoever.
I want to make sure we're all on the same page, that I don't want anybody to think that the commission allows to open a braiding head and the valve and pump cement down it. We don't allow that. So make sure when we talk braiding head squeeze, we're talking about putting cement in that space, that open annular space, not pumping down the braiding head, because that doesn't do anything. And I don't want also our perspective is that fluid flowing is fluid flowing. We're not disputing this concept of commingling hydrocarbon zones and water zones. We're not trying to discuss that. Yes, that's one element of wellbore integrity, and for sure we don't want that. But in this case, what we're talking about is water flowing out of the wellbore that's not, we consider inappropriate.
Mr. Chair.
Commissioner Alward.
Thank you, Mr. Chair. So we heard some testimony, which I'm assuming, it's outside of my expertise, so I'm assuming is accurate with the relative compressive strength of cement versus steel, which I appreciate is a large difference. Is the strength of the cement sufficient to withstand the pressures that are likely to be seen in this well?
Want me to answer?
For me.
Okay, go right ahead.
Well, both or
Yeah.
whatever.
If there is a good seal of cement around that casing, it should be sufficient. Okay, the risk is, and it's a very great risk in this case because of the well bore geometry, because of the inclination of the well itself, and because of the age of the mud in the well bore, there's a very high likelihood that you will not get a good seal of cement all the way around that pipe and throughout the well bore. So even if you have 5,000 PSI compressive strength cement, without a complete seal, you have nothing.
I would probably concur with that in the sense that steel, you talk about 10,000 PSI, steel strength.
I'm just more concerned with if we got that strength, if we got a good cement seal, is that a sufficient strength to protect the various formations, given the pressures that that well is likely to be subject to?
Yes.
And then another, is this Exhibit 14 that you've got up there?
Yes.
What do you see is incorrect about this depiction of the well bore and the water formation?
A number of things. As I said before, and I don't think we pointed out one of our slides, there's a deeper zone around 2,800 feet, 2,900 feet, that is also a fairly high porosity, well over 20%. In fact, I think the average porosity is 28%. It's about 100 feet thick, and it looks like it is a gas-bearing zone. So generally, as one of your prior witnesses testified, the higher your porosity, the higher your permeability, and the better chance that you're going to flow hydrocarbons from it. So that zone is deeper than their deepest plug that they would like us to set. If
just this, I'm sorry, I thought this was 14, which doesn't have any of the plugs in it.
That's right.
It's just a depiction of what the formation might potentially look at. And in particular, just so we don't go off, they've got water throughout the uncemented annulus depicted in this. I would like to know if you agree that that's a reasonable depiction or why it's not.
No, it's not reasonable because we know there are gas-bearing zones there at the top of the Mesa Verde as well as in the Wasatch. Okay, so in fact, if you look at the induction log, there doesn't appear to be a lot of indication of fresh water in the Mesa Verde zone until you get fairly deep.
I might not be being clear, and I apologize for that, but I'm looking at the vertical, the annulus there, they've got it all colored in blue.
Right.
Is that, I mean.
That's what I'm saying. It can't be accurate.
Regardless of other formations down there.
I'm saying it can't be accurate because they're indicating water all the way down to 5,100 feet. And what I'm trying to point out is we know there are gas-bearing zones as shallow as 1,650 feet. And it's very likely if there was not a seal, we would see gas coming up that annulus and not just water.
So what is the lowest level of what you know is a water-bearing sand? Just water. 1,600 feet you've established as possible gas. 1,600 feet and below. What is the lowest water-bearing sand?
I have the induction log with me.
Okay, good. Tell me what it is.
I can whip out, down at probably 6,100 feet, there's water in that zone. That's not what you mean.
No, I mean, are we talking 1,000 feet? What is happening between the surface and 1,600 where you show us where there was a little bit of gas formation? What's happening in there? Why can't you go ahead and just do a plug cement squeeze at the lowest water-bearing zone?
Because of the dangers, number one, of not getting a good solid cement job in this wellbore, okay? That makes it very risky. If you don't get cement all the way around that casing and seal it off, you have exposed those water-bearing zones to the high-pressure gas from our producing zone at 7,300 feet. And that's very risky because then you are contaminating those water-bearing zones with that gas, with those hydrocarbons.
Well, I'm kind of stuck here because right now, we're not going to go ahead and let this condition go as we have it now. And I'm trying to think of a way that we can isolate the water-bearing zones from the productive areas and meet Rule 317. What can I do? I mean, I'm stuck. I am really stuck here.
Ma'am, that's
Because
what,
we're not going to allow it to continue to flow.
and what I'm trying to tell you is the safest way to do that is through a Braden head squeeze. If you punch perforations, holes in that casing, you have a much, much, much greater risk of having communication with hydrocarbons than you do now.
Could you quantify that risk?
It's 3 or 4 orders of magnitude
But
greater
given
than what you have now.
what is, I mean, but 3 or 4 orders of magnitude could be 0.00001 versus 0.001. And that's a very small risk either way. So I'm trying,
Well, okay, let me rephrase that then. That's a very good point, because right now, the risk of continuing to flow water out of the annulus, the risk of environmental damage or any health hazard to the public is 0. Okay, that risk will increase over time because of the potential degradation of that casing from inside much more than outside.
How can you say that when you don't know what type of crossflow that you have? You don't.
Because we know what's coming to the surface.
Not if you've got crossflow. There's no guarantee that what's coming to the surface is that you don't have some flow below and the water is flowing out of the upper zones. I mean, on the basis of what I've seen here, I don't know where I have wellbore integrity. I know I don't have it because I've got some flow, but where is it? This is a 34-year-old well.
Correct.
That's a pretty old well.
Yep.
And I totally can understand why you may not want to go ahead and put holes in the casing and whatever else. But I guess what I'm saying is we're not going to let it keep flowing up the backside. So where's the answer in here? I've mentioned that maybe you try to perforate below the lowest water zone and see if you could circulate cement to the surface, but you say that's too risky. Well, for us, we kind of have a rule here that we've been emphasizing to the people in this state that our priority is wellbore integrity, that we have got to have wellbore integrity.
We have wellbore integrity here. This well passed a mechanical integrity test April 1st of this year. So under the rules of the Oil and Gas Commission, and your inspector was there to witness that integrity test, it passed wellbore integrity. There's a redefinition here of wellbore integrity if you're claiming it doesn't have it.
You guys want to comment on that?
Yes, the steel of the production casing passed a test, but the exterior, this Braden head space, is flowing fluid. Flowing fluid out of the Braden head is not wellbore integrity. He's speaking about a test of the steel casing, and that's it. But the assumption in that rule is that nothing is flowing out of the Braden head. That is an inherent wellbore construction perspective.
And I have to concur with you that wellbore integrity is not just the casing, it's the cement, it's the equipment that we place on that well. It is everything. It's the jewelry that goes down hole on the casing. It is everything. So Bill, I need your help here because I'm stumped.
I would agree with Mr. O'Hare that we've got a risky repair.
I agree.
But I also believe that we should not allow wells to produce without mechanical integrity or isolation of those zones. So I'm kind of in the same place you are. And my feeling is that we should try to repair the well if we're going to allow it to continue to produce.
Well, then the Braden Head squeeze is our best option. It is the least risky. It has probably the best chance of success.
I want to again reiterate, no pumping down that Braden Head, because you'll get cement 10 feet down that Braden Head and then you know nothing.
You don't know anything.
So when we say Braden Head squeeze, pumping a Braden Head squeeze, let's make sure we're not speaking in regards to pumping cement down a valve at the surface.
Well, and that's what you're talking about doing.
The only other way to do that would be to take off the wellhead and run pipe alongside the outside of the production casing between it and the surface casing. And then cement through, you can actually run 2 strings and cement through both of them at the same time. That would be the only other way to perform a Braden Head squeeze.
I've got to depend on some of you experts a little bit more. I'm a pretty simple guy. I'd kind of like to know. I just would be curious. What's the water quality in these springs that are around compared to the water quality coming out of the well? I would be curious what would happen if you go ahead and shut that Braden Head off and build up the pressure and see what happens to the quantity and quality of water at the spring. I would just be interested. I don't know that has anything at all to do with coming to a solution here.
I just got permission last week from the landowner to collect samples and have them tested of his springs.
So, experts, engineers, folks that sort of know what's going on,
well,
gnomes, or anybody that knows what's happening down there 6,000 feet.
Well, what we know is that there's zones that are not isolated.
Are there freshwater producing zones?
Could be freshwater, could be gas zones. They're not isolated. There could be some kind of seal that's preventing some of that from getting to the surface, but beyond that, we don't know. It could be communicating with other zones behind pipe. My inclination is to try to do the cement squeeze to try to isolate the zones.
Below the lowest
But
water.
Marilex is not, they've suggested it's
Well,
too
I think
risky.
what their proposal though is really just to stop water flowing at the surface. And we still have all those zones open. We just don't know what's happening to it.
And so we still run the risk, even though we stopped coming to the surface, it's going somewhere.
Yeah, it's moving behind pipe and.
Okay. I need help, Dr. Allward.
You're going to need to look for some other source of help, I think.
Well, I don't, I think the staff has made a recommendation. They've looked at other wells in the area that have been successfully cement squeezed, albeit maybe at a little different wellbore geometry. And my inclination is to accept the staff's recommendation.
Okay. Although that wasn't like a motion or anything, it certainly, sir.
Do you have any cross of this witness?
Oh, sorry.
I do have a few questions, Mr. Berger. You indicated that salinity, quote, could be increasing, but you don't have any evidence that it is, do you?
Yeah, right, there's no evidence of that.
And you said oil and gas commingling is possible, but you don't have any evidence of that, do you?
No, a lot of the samples that Marilex refers to having collected we do not have in our database.
But you don't have any samples that show any hydrocarbons in the water?
Well, that's not correct. There's a sample from 2011 that shows benzene in the water.
But that
is a hydrocarbon.
Okay, let me rephrase it. There's no oil and gas that you can identify coming from below the surface.
Right, we don't know the origin.
And you do have water test results.
One water test result, yeah.
And you indicated that the difference between the strength of the cement, you criticize the characterization that was really dangerous to do the perforations in the cement squeeze. You would agree it's a higher risk of doing that than leaving the steel casing. There's a higher risk of something happening during the procedure, that it doesn't hold the cement, it builds up some pressure, there could be a blowout. Those are possibilities, correct?
Actually, I sort of disagree with that. When you place cement in that annulus, it changes the way the pipe is held in place. There can, if there's some potentially corrosive water flowing, it will then not be flowing against the pipe because it will be prevented from flowing against that by the cement. So you can reduce your risks of corrosion by having cement in that annulus. You can also reduce the risk of anything moving up the annulus because you formed a seal around the pipe.
And all the water is fresh water, less corrosive water, correct?
What water?
The water that's coming to the surface.
Well, from the one sample I have seen, it was moderately fresh, yeah. 1,600 parts per million.
And Mr. O'Hara testified that there's no guarantee that you could get a seal. You know, we showed you those slides where there's the old mud and the channeling. Do you agree with that testimony?
That's a possibility. I'm not familiar with the way the well was drilled back in 1981. Usually what happens when these Braden head remediations are performed is an operator will select a likely place where a plug will be effective. They'll perforate and squeeze 100 or 200 sacks of cement into that annulus, and then open up the Braden head, see if their pressure problem has been mitigated. If so, they monitor for a couple of years, and if it's successful, it's good. And if not, if you still have Braden head pressure, you move up the hole and try a different squeeze at a different depth. And you know, sometimes that's 3 different depths before you get the result you want. It is a fairly expensive process. It's not an insignificant cost.
And in his report, he talked about various washouts in the hole. Would that have an effect on the cement process?
Yeah, the operator should evaluate his hole and select the proper place to put a plug.
And that's all the questions I have. Thank you.
I need some guidance here, okay? Because I want the water to stop flowing, okay? 317, it's a black and white issue for me. We've got to get control of that well. Now, I put forward a little suggestion that below the lowest water zone, you go ahead and pump cement, but you didn't like that. I need help here because we've got to get control of that well. There's no ifs, ands, or buts. I'm not willing to take a risk and go ahead and, you know, work some more on this problem and whatever else. The issue we're facing here, we either go do some remedial work or that's it. I don't see any other alternative here. I totally agree that this is a risky proposition. I totally agree that that cement is very old and probably dried up and heaven only knows what's happened with it. I really can't tell you what's flowing from where, what's flowing to what zone from here. I just don't like that. You know, from an engineering perspective and sitting on that side of the table, I think it'd be a real interesting problem to work. But the reality is I'm sitting on this side of the table and I got to work with certain rules, and one of them is no uncontrolled flow. And that's what we have here. And to a certain extent, I feel like there but for the grace of God, do we have an even bigger problem, because what's stopping what from flowing where? I don't know. Dry mud, maybe cement. I mean, the cement didn't look like that good of a cement job to me. So I'm stuck. I mean, I think that what we're coming down to here is the fact that either we do something like staff's recommendation and get the well under control, or that's the end of the discussion. That's where I sit. I don't know where the rest of you are, but you know, talking about washouts and whatever else, yes, washouts give you a lousy cement job. I totally concur with that discussion, but it doesn't change the problem that I have to work under the constraints of 317, and we have to maintain control of a well. No uncontrolled flow, and that's what I've got. So unless we can go along with the staff, we're done.
I'm not sure what you mean by uncontrolled flow. We are controlling the flow at the surface.
Can you shut the well in? So
We
it's,
can, sure. It was shut in for 30 years. The state is who is keeping us from shutting the well in. But the well had been shut in for 30 years.
but you're not controlling where the flow's coming from.
We're controlling the flow at the surface. And it's going into a tank now, and that fresh water is being hauled off and disposed of 8,000 feet below the surface.
Staff, do you want to comment on that?
Well, it's very difficult to comment on that question because flowing water out of the Braden Head falls into many bailiwicks. We've got the wellbore integrity, we've got the water resource issues. This starts to escalate, and so it's very hard. The typical method, the perspective goes all the way back to, you just can't have fluid flowing on that back side. We are in a spin cycle of what ifs. What if it's moving to a different zone? What if it could be corrosive? What if it could be this and that? You know, it's hard to answer. Those are many, many difficult questions that are unanswerable. We're in a spin cycle in my mind, but you drift back, to me, you drift back to a simple perspective that fluid should not be flowing out of a well and around the casing, and that's what we need to. And that's the perspective of wellbore integrity, is making sure that we don't have fluids flowing. And that's my perspective. And that's my interpretation of 317.
Well, I mean, some operators do design wells to flow up the backside. Let me just go ahead and state that. But they've designed it for that.
Well, I'd prefer to describe a impression of tubing casing backside, not necessarily the backside of the open wellbore. Yeah. Well, maybe. Okay.
I'm sorry. I am ready to make a motion that we have to go ahead and control this flow. The staff has put forward a recommendation. I'm supportive of staff's recommendation.
What does the Division of Water Resources say? I mean, I can't pump a gallon of water without accounting for it. And this is doing 9 barrels a day. You'd be visiting me.
You what?
You'd be visiting me.
I would. That's a fair question.
And I'm not even going down that bailiwick.
So I think it's relatively straightforward. We, back in May, directed Marilex to come up with a plan to stop the flow. And there's no plan here. Regardless of the complexity, the difficulty, the risk, there's no plan here at all. And thus, we're stuck with the staff's plan whether we like it or not. I mean, I guess we could come up with a plan here if we wanted to, but I think we've had plenty of time, and all we have is foot dragging and speculation as to what might be going on downhole, whether it's all open and communicating, or the casing's up against one side, or there's somehow mud dehydrating under flowing water conditions. We've got a lot of speculation. That's not what we asked for. We asked for a plan. We don't have a plan. I say, I concur with Commissioner Craig. If the staff has presented a plan, and
Mr. Commissioner, we do have a plan. It is a Bradenhead squeeze. It is not a risky plan. It is not a dangerous plan, but we do have a plan. And we ask for your indulgence there and recognition
I don't
that
think
with
I
the
asked for
staff's.
the comment, though. We don't.
Have an acceptable plan.
I mean, it's wait to some future indeterminate time to do a Bradenhead squeeze. I would like to see a time schedule here, and I'm not seeing anything that would tell us when the plan is implemented, whether we're achieving the results we want. There's nothing in here except for let's sit back and wait until maybe the staff forgets about it.
Well, we're about maybe reach the point to close the record. Unless, one last shot from the parties. Okay, yes, no, maybe.
No, nothing further from staff.
Mr. Chairman, I mean, Marilex would be willing to, point by Commissioner Allward, about a time frame of performing the Bradenhead squeeze, would be willing to, you can impose a time frame on that, other than having it, we wanted to test and see what would happen if we did turn off, close the valve and see the water pressure build up and test the water. And, and it was, there wasn't a timeline, but, we'd accept the timeline if you want to impose one on the plan to address the concerns that it's open-ended.
I just want to make sure, I want to make sure that if you all approve something, you do not use the words Bradenhead squeeze, because we will not approve that type of remediation method of pumping down the Bradenhead. So make sure you, please don't use those exact words. You can fill the Bradenhead space, but don't use the word Bradenhead squeeze. That's a different technique than the poking holes in the casing or using a 1-inch quote spaghetti string down the backside. Those are three types of cement jobs. They're specific.
Say that again?
We have discussed three types of cement, types of ways to cement this hole. They are what staff recommended of poking holes and placing the cement in specific locations. There is the idea that Mr. O'Hare brought up in regards of removing the wellhead, grabbing a hold of the casing and drawing it taut, and then running a 1-inch steel pipe down the backside, going and placing those cement with that method at 1,600 feet in several locations. Then there's the third method, which I consider the poor boy method of grabbing a hold of that Bradenhead valve, hooking a pipe up to it, and pump cement down that backside as hard as you can. That's called a Bradenhead squeeze.
Stuart, I'm not sure I like your number 2 discussion. You're open at that point.
Well, you would have to control that, well, the fluid flow, and
Right.
it's a fairly common method here on the east side.
Yeah, but if you don't know what zones potentially could be open, we've already discussed the cement's not very good.
Yeah.
Mud's kind of dry. Maybe it's providing some restrictions. I'm a little nervous about that, Stuart.
Well, option 1 is and then there's option 2 and option 3. So I just want to point out that commission's policies, we do not approve braiding head squeezes. That's all my little point right there is to make sure y'all don't use, if you amend this order, I don't want you to use those words.
You had considered the 3 alternatives originally.
We never
and this is
considered that
the
one.
third one, but you
we tossed that one
considered
down.
number 2. I mean, but you did
that's
say, yeah, it
it's a method.
exists, but we're not doing it.
Okay, Ms. Craig speak.
I just want to know, you looked at all 3, and this is the one you came up with.
Yes.
Okay.
That's good.
I don't want to modify staff's proposal.
No, I don't either.
Maybe
That's
we either
staff
take
proposal.
Marilax's or we take staff, but I'm uncomfortable taking
I'm
on
not
the
gonna-
liability
yeah.
as a commissioner trying to redesign a well.
Okay, let's close the record. Record is closed. Commissioners, now you may deliberate.
Well, I'll start. I agree with Commissioner Craig that we need to control the well. We need to isolate the zones. I think staff's proposal is reasonable and appears to be the preferred method to try to put control in the well. And so I would support that.
Other comments?
Thank you, Mr. Chair. I believe we've got 2 things we're dealing with, right? Whether we've got a violation of Rule 319B1, which is the failure to conduct an MIT, and then will the plan, such as it is, stop the flow?
I thought we
So-
did the MIT. Do we not?
No, we did the penalty payment schedule. So we still have these 2 issues. So here is an outline of what might be a motion. I'll let my colleagues chew on it. So one is find a violation of Rule 319, B1. Direct the parties to implement the staff's proposed plan or another approach agreeable to the staff. And this plan will be implemented and reported to us by the December hearing. If that is accomplished, then I'd say we would waive or reduce any of the fines. We would postpone payment of the fines until the December hearing, potentially waive them if everything is accomplished, or else the fines for the failure to conduct the MIT and to stop the flow would come into effect in December.
No, that wasn't a motion, but it was a suggestion for a motion.
So that there's a lot of details in there that may or may not be satisfactory. I haven't thought through it all as far as its feasibility.
Well, the one thing that you open then is you do provide Marilex an opportunity to come up with an alternative plan that would be acceptable to staff. And I don't have a problem with that.
And it would have to be in very near term in order to get everything done in the near future.
Can I ask a question on that? Are you kind of mixing apples and oranges, though, by not making a determination on the rule violation and following through with the fine and mixing that then with the second issue?
That's a lawyer question.
Yeah, from the non-lawyer.
Yeah, and from a non, so I'll give you my unqualified impression. So that's where I'm looking for some help too, and how that will come together. I'm trying to put a carrot out there to get things to happen as quickly as possible. And so whether we put that whole MIT fine and everything else in there, or what parts of it we might consider deferring or reducing. I think we need to discuss that.
I'm worried about precedent setting on the violation and fine piece. So, I mean, it's either they did or they didn't, as far as that piece goes. And then if you want to put a carrot on the plan that by December something happens and then you create some sort of forgiveness in the amount equivalent to that, then that way there you sort of keep the two issues separate, if that's of relevance to the lawyers in the group. If it's not, I think, at our department, we try to sort of keep issues sort of in their proper boxes so as not to create a potential precedent by coming outside of that.
Is that something legal counsel can speak to, or?
Well, Doctor, nothing that Commissioner Howard said concerned me legally speaking, and I understand what you're saying in terms of precedential concerns. The order that you amended from the last hearing approved a payment plan, and I think you could actually build that into the order that you're talking about. And the second or the third payment or piece of the fine is forgiven or not due and payable if certain benchmarks are achieved by December.
I feel better. Thank you.
I'm not sure Mr. Spielman does.
Mr. Chairman, if I may.
Please.
Thank you, Mr. Chairman. We have a motion. I will not be seconding it.
We don't actually have a motion.
Don't have a motion, excuse me.
It was, so you could make one, actually.
It doesn't, we're here to do the people's business, and Mr. Zemsky and Mr. O'Hare, thank you for making the trip and appearing in person and taking these issues so seriously. Staff has spent a lot of time, the commission has spent a lot of time, and I, for one, think that people are entitled to some resolution here in addition to the operator. And I'm uncomfortable with continuing these discussions for another 4, 5, 6 months. This is, by my count, the third time we've visited with this operator in the past 8 or 9 months. And I believe staff has, we've provided opportunities for an alternative resolution to that proposed by staff. Staff has visited with the operator, has testified today that they don't believe the alternative arrangement is in the public interest. And I am prepared to move that we approve the staff's recommendation, particularly deferring, frankly, to my colleagues on the commission who are petroleum engineers, and hearing the discomfort with what I hear is a per se violation and a lack of an adequate remedy, alternative adequate remedy.
Okay, I believe I heard a motion to
Thank you, Mr. Chairman.
approve the staff recommendation.
Second.
And a second. Any further discussion? Hearing none, all those in favor indicate by saying aye.
Aye.
Opposed, same sign. Then the staff recommendation stands approved. Thank you all very much. Well,
We're not done.
okay, we have one other item, I think, Ms. Murphy.
Just as a clarification, Chairman, sorry to interrupt. Was that also a motion regarding the Rule 319 B1 violation?
That's my understanding. Yes.
Okay.
Yes.
Just
Yes, Mr. Chairman.
We have one other item. I know that one of my colleagues has to leave here pretty soon. So if that's necessary, we wish you Godspeed. Hopefully we can just go ahead and work through this other one relatively quickly because I don't see a lot of folks here to discuss it. Okay, docket 150700166 Ranchers Exploration Partners LLC. Ms. Beckstead, you're still at the top of the list, so I assume you'll introduce this and Mr. Rouse will straighten us out.
Actually, I was going to introduce it, Mr. Compton.
Thank you.
Thank you. This matter was set for the Commission's July 20th hearing by virtue of a notice and application for hearing issued on May 28, 2015. Counsel for staff requested appointment of a hearing officer because Ranchers was ignoring the notice and application and was not communicating with enforcement staff. On June 19th, the hearing officer issued and served on all parties the initial pre-hearing conference setting order for this case. The setting order provided that failure of any person to attend the initial pre-hearing conference would be deemed to be a concurrence to any agreement reached or to any order or ruling made at the pre-hearing conference, including entry of default judgment or dismissal of a protest. This is in accordance with Commission Rule 527F. Also on June 19, the hearing officer issued and served on all parties the hearing officer standing order. The parties were ordered to confer prior to the first pre-hearing conference and endeavor to reach agreement on a joint proposed case management order. If the parties are not able to reach an agreement on the case management order, each party was ordered to submit a proposed case management order to the hearing officer 24 hours prior to the pre-hearing conference. Ranchers failed to comply with these orders. The hearing officer standing order also specifically provided that in accordance with Rule 527F, failure of any person to attend the pre-hearing conference after being notified of the date, time, and place shall be a waiver of any objection and shall be deemed to be a concurrence to any agreement reached or to any order or ruling made at the pre-hearing conference, including entry of default judgment or the dismissal of a protest. Staff filed its proposed exhibits for this hearing. On July 2nd, 2015, the hearing officer entered and served an order giving Ranchers until 5 p.m. on July 7, 2015 to file any objections to staff's proposed exhibits. Ranchers did not file any objection to staff's proposed exhibits. At the initial pre-hearing conference on this matter, it was convened pursuant to Rule 527 at 1 p.m. on June 25th. No one appeared on behalf of Ranchers. As a result, default judgment was entered against Ranchers by the hearing officer. On July 8th, the hearing officer entered the pre-hearing order for this case. The pre-hearing order provides that because of Ranchers' failure to appear, communicate with the hearing officer or staff, or otherwise defend against staff's allegations, there are no disputed factual or legal issues. The pre-hearing order also deemed all exhibits proposed by staff to be authenticated and admitted into evidence before the commission. The pre-hearing order, in addition, provided that because there were no disputed factual or legal issues, neither party will present any witnesses. However, as part of staff's presentation, Denise Arthur, Reclamation Supervisor, and Margaret Ash, Field Inspection Unit Manager, are available to answer any questions any of the commissioners might have. Because the staff recommends, or hearing officer recommends, that because there are no disputed factual or legal issues, the commission should enter staff's proposed order finding violation. And I don't think Ranchers has appeared at this hearing, so we can skip that. Staff has 15 minutes to present its case so that you have some comfort level with what's being done and what's going on. Recommended order is for commissioners to recuse themselves if they have any type of conflict of interest, and then staff's presentation, commission questions, and deliberation and vote. With that, I'll turn it over to Ms. Beckstead.
Excuse me.
Britta Beckstead, Counsel for Commission Staff. So as Hearing Officer Rouse mentioned, Ranchers has failed to appear, and staff is prepared to give its case presentation if you would find it helpful. However, we'd also give you the opportunity, since all the materials are in your portfolios, to simply ask questions if you have any.
Just to be clear, are Ranchers, is Ranchers or a representative present?
Business.
Okay. My preference would be to ask questions of staff if you have any. You don't, I'm assuming you don't need to hear their presentation. You've read it. You understand it. Okay. No questions? Oh dear. Commissioner Benton.
There we go.
I move that we accept the staff's recommendation.
Second.
We have a motion and a couple of seconds. Is there any discussion? Hearing none. All those in favor indicate by saying aye.
Aye. Aye.
Staff's recommendation is approved. Thank you very much, Margaret and Denise, for a job well done.
I was at a loss for words.
Ms. Murphy, I conclude. I think we're through.
I certainly hope so, sir.
Thank you very much for your hard work today, and we'll adjourn our meeting. Thank you, Enrique.
And we look forward to seeing everyone in September in Gunnison, minus Commissioner Spielman.
September in Gunnison. Sounds like the title of a good Western novel.
Right? At least some great hiking. You're out.